Sorry for the delay. This court is of the considered opinion that exercise of suo motu powers of revision, which is available under Section 29D in the instant case, does not appear to be unreasonable, and the enhancement of the penalty appears to be justified. Writ petition is accordingly dismissed.
Keep your note. My lord, can I make a prayer for listing of a motion matter tomorrow? It's a transfer matter, my lord.
Motion is.
Deeply applied.
May I please, your lord.
It was first bench.
May I please, your lord. May I please, your lord. I beg to mention item number 1.
Yes.
The CCC Lordship KK Paraswar is on medical leave for his relative. Lord.
So 13 matter.
On first week of
There are many
September.
CGCs.
I appear for the Mr. Parasar for me yesterday.
No, that is okay. But Parashar is not the only CGC. 13 matter. You make an alternative arrangement. We'll accommodate for today. But we'll have it on, immediately we'll have it. 13 matter. Cannot afford.
Lordship on 3, Lord. 3rd of September.
Today is,
27.
okay, we'll have it on 3rd of September.
Obliged.
It is submitted that Sri KK Parashar, Leonard CGC, is on medical leave.
Lord.
He is unwell
No,
over.
no, not he is unwell.
He
His
is
relative.
on leave on medical grounds. And therefore, an adjournment is sought for para. Considering that this matter is of the year 2013, list on 3rd of September, 3/9.
Obliged.
May I please, Lordship, the matter is about appointment of police constable. It was last posted on 23/5/2022. Accordingly, order was passed to list after 2 weeks, but till date it has not been listed.
Matter of which year?
2022.
22.
Yes.
22.
22.
Okay, 22 matter will have a date.
Lordship, any date in the second week of the September.
Give a date.
Lordship.
May I please, your lord. I beg to mention for listing of a matter for admission, lordship, matter pertaining to dismissal from service, lordship. Lordship, matter was last posted on 22nd.
Matter of which year?
Lordship, 2023, lord. Lordship, any day convenient to your lord.
23 matter out of turn listing, not the
Lordship, matter
proper.
was off-listed, lordship. I have made an application before registered, lordship. However, matter has not been listed. Any day convenient to your lord.
It's not a question of our convenience, it's the question convenience of the system. 13 matters are pending. How do you give preference to 23 matter? Tell us. Sorry.
May
Next.
please, your lordship. I beg to mention one date petition for withdrawal.
Withdrawal. Withdrawal,
matter.
we will have it on when?
Day after tomorrow.
So no, on Friday.
May I please, the lordship? Lordship, I beg to mention item number 13.
1/3.
Yes, my lord.
Yes.
The engaged counsel is out of station, my lord. Therefore,
Who's the engaged counsel?
sorry, my lord.
Who's the engaged counsel?
Mr. A. Lal.
16 matters. Difficult. Where are you making mention? Who's on the other side? Mr. Bora, you are there. What is the matter about?
The writ petition, my lord.
What is it about?
ACP, MSP, lordship.
ACP, MSP, what is there to be decided? Yes, when will it be back?
My lord, maybe please to fix it after 2 weeks.
2 weeks since. A prayer for adjournment has been made on behalf of Sri A. Lal, learned counsel for the petitioner. Para, list on. On 5th of September,
Obliged, my lord.
16 matter, 5/9.
I didn't follow for motion.
May I please?
Yes.
And the attachment was taken the instruction.
They have reached the inspection.
What is the matter, madam?
That,
Regarding selection of the ASHA worker.
Nine position out of nine. There are serious allegations against you.
my lord, page number 18 kindly.
You, madam, you file the affidavit. We issue a short notice. Allegations of forgery is against your client.
No, my lord, selection list itself, it says that I was selected, but.
Let them file the affidavit. It might take a different turn, but we want to give you an opportunity. Apart from the fact that you were last in the select list, in the selection, 9 position out of 9 candidates. And thereafter, you had used the roll number of another candidate, Parvin Sultana.
Initially, which list was published, my lord, I was only the selected candidate.
Let us see.
Then subsequent.
Third, Sri
Please.
G. Islam Learned Council for the petitioner who has filed this petition with regard to a recruitment process for the post of ASH Asha worker for the village Chatian Toli in the district of Morigaon. Full stop. The petitioner claims to have been selected. Full stop. However, she has not been allowed to join para on the last occasion, that is 19/8/2024. Miss A. Bora, Learned Standing Council NHM, was directed to obtain the instructions in pursuant pursuant thereto. Instructions have been received and placed on record and placed before this court. Full stop. Para. Let notice be on record placed before this court, which however reveals that there are allegations against the petitioner of indulging in forgery. Full stop. Para. Be that as it may, comma. Let notice be issued returnable by 4 weeks. Ms. Bora, Learned Standing Council, NHM, accepts notice on behalf of or year for 2 and 3.
Yes, my lord, 20.
Joint Director, Member Secretary, District Health Society.
Yes, my lord.
Then health.
L.
Anyone health?
D. D. Bora, MSc.
I submit both also.
Whose name should we record, madam?
That was
Deepa Bora.
Deep.
Okay. Miss, is she there in the court today? Miss D. Bora, 1. Then A. Bora for 2 and 3. 4 is D. Bora 1 and 4. 1 and 4. 2 and 3 Khulban or 5 registered post PTD. Steps leading to this. You file the affidavit. You take this back, madam.
Wait, please do. This matter of challenging the termination of service of petition.
Mr. Chaudhary, you are for which matter? P. Chaudhary? Mr. Chaudhary, for which matter?
I give 19 years.
It'll take some time, come after some time. There are some matters top of the list. Mr. Das also, perhaps, which matter? 5. There are 2 matters on the top of the list. We'll try to finish those. Yes, what is this?
this is basically I'm challenging the termination of service of the petitioner
Okay,
without enquiry and without having any notices given to him. Just
he was serving as
he was serving initially as your lordship in the as attendant in the
where?
Tea Research Association under the Toklai Tea Research Institute, Jorhat. He was initially appointed on 8/5/1986. I'll just give a gist of that. The date of appointment as 8/5/86 as cleaner boy in the library and publication department of TRA, that is Tea Research Association. Then on 1/4/2006,
Hmm.
he was promoted to grade AD1 within bracket 3. This is some kind of their grade. Then what has happened, your lordship, it starts from here. On 1/6/2009, one person called Kailash Saikia, who is now no way concerned with the TRA, has filed a complaint under section 138 of the NI Act, and that was registered as CR case number 191 of 2009 before the CGM court at Jorhat. So that started the matter, your lordship. What has happened in this case? The petitioner, the allegation was that the petitioner availed some loan from him. 2 checks were issued, which bounced. So there was a proceeding under the NI Act. In the NI Act, your lordship, what has happened? I'll just come directly to the order. On 10/6/2014, the judgment was passed in the NI Act, and he was convicted. He was convicted and sentenced to undergo a simple imprisonment of 6 months and also pay a compensation of 2 lakhs. So this is basically the start of the matter, your lordship. Thereafter, your lordship, on 4/9, I'm just giving that dates and then I'll come to the law points. 4/9/2014, the petitioner was arrested.
Who is for the other side?
नाम तो स्पष्ट पूर्ण आता है other side.
This.
Just Roy.
No, who will be defending? TRI.
Yes, your lordship. This is actually Union of India is also there
No, but who will
because
be
it is under the union.
who will be defending?
And then I think TRI, somebody else is appearing. And for TRI, I think, yes, TRI is P. Pathak. No, sorry, P. Pathak is assistant SDI. And SDI, SS Roy, Nursery, Hormone, all these. Hormone is appearing for
P. Burman. Can you call her? Names are
number.
shown.
Could
P.
be
Burman, Puri Burman. Number আছে? আচ্ছা।
ঠাকুর
বাহিনী নার্সারি as walk
সান্তানু নহয় এইটো মিস
as walk.
সাংটাকটো নাই কি পাঠক এটা করছি কোন পাঠক
It is Pranab Pathak. His team is there. A. Nursery, P. Burman, as walk. I think Madam Burman is regular in the court. P. Burman or walked is there as walk.
I know her.
কইতে আছে
We'll just try to locate her.
Yes.
In a while, we'll take it up. Hello, Pisar Matibu.
Very small issue, your lord. Basically,
Affidavit have been filed.
yes, affidavit has been filed, and I'll go by the your lord statute.
Next month.
Yes, trust by the not
Otherwise, Mr. Mazumdar was appearing, but then this matter, nothing remains like this topic. This is regarding the SPO's lot
Oh, earlier rounds.
earlier on. Engagement of Homeguard as SPO's lot. Mr. Mazumdar was to appear, but he's on late at the court.
But the entire SPO's engagements were discontinued, isn't
Lordship.
it? SPO's engagements were discontinued.
Discontinued back in 2015, Lord. Thereafter, they have some of them have been engaged in the newly AISF battalion, Lordship.
Yes, that we know.
The recruitment that started in 2017.
Heard Sri Dideka, Learned Counsel for the petitioner. Also heard Sri D. Bora, Learned State Council. Full stop. Para. The matter pertains to a challenge of discontinuation of the members of the petitioner society who were special police officers.
Special police officer.
Full stop. It is the case of the petitioner that in the year 2007, pursuant to a decision of the central government, 1,000 numbers of SPOs were engaged on contractual basis, mainly for providing security with the aspect of construction of the 4-lane east-west corridor under the NHAI. Full stop. Though the petitioners were serving since long and were demanding for their regularization, including hike in their monthly remuneration, their grievances were not redressed, and ultimately, from June 2015, they were not allowed to perform their duties. Full stop. Para. Sri Deka, the Learned Counsel, has however submitted that subsequently the AISF, Assam Industrial Security Force, has been constituted, in which the incumbents who had earlier rendered service as SPOs have been given preference. Full stop. Sri D. Bora, Learned Counsel, Run State Council, has submitted that in view of the subsequent development, the no effective relief can be given to the petitioners. Puts the para. This court has noted that the AISF has been constituted, wherein SPOs and home guards are given preference. And it is the case of the petitioner association, petitioner society, that many of its members have subsequently been given the benefit under the new scheme. Full stop. In view of the aforesaid facts and circumstances, this court is of the considered opinion that there may not lie any existing cause of action to be adjudicated. Full stop. Para. Writ petition is accordingly closed.
Please.
Well, this, your lordship will kindly note one page. On 10/10/2012, this petitioner was promoted as divisional head assistant. Then thereafter, there was suspension, and
disciplinary proceeding without.
What
any
is the cause of action here?
Cause of action 2, my lord. Now
No, what is the cause of action?
disciplinary action.
Remove, I mean, a punishment.
Now censure has been given. Period of suspension from 2020 to 21 to be treated as leave at his credit and censure. These are the
Censure has been,
Censure.
you are challenging the censure.
censure and this period of suspension.
Okay. The outcome of the disciplinary proceeding.
No. First is, my lord, first they have given they demoted, but later on appeal was filed. And in appeal, my lord, they have given this. So two grounds and another is that, my lord, petitioner's annual increment has not been given as a head assistant.
Okay, kindly tell us the facts.
Facts, my lord, your lordship will kindly note only that 10/10/2012 he was promoted as divisional head assistant.
Initially appointed when? As?
My lord, that I will give you. I'll provide it.
Yes.
Initially appointed as lower division assistant. in
When
1980.
was it?
That was on 36/87.
36/87.
Yes.
In the PWD.
PWD. Then thereafter he was promoted to UDA on 7/5/96.
7/5/96.
Then he was promoted to, my lord, in 2012 as divisional head assistant.
2012.
12. So he was suspended on 19/5/20.
Divisional head assistant.
That is 2020, 19/5/20, he was suspended.
19,
5/20,
2020. Suspended.
suspended. Then thereafter, my lord, no charge sheet, no total violation of under Rule 9. A disciplinary proceedings was initiated only by giving show cause notice. And there was no charge sheet, no list of witnesses. For that purpose, your lordship has called for the record. And the disciplinary proceedings has inflicted this punishment. Your lordship will kindly see page 52. 26/7/21.
26,
7/21.
52.
Yes, 26/7/21, page 52.
Yes, please. Twenty. 26/7/21. Yes.
Hmm. That is the order in 44.
Oh, penalty order. Penalty.
Yes, censure, reduction of his post from head assistant to senior assistant. Page 52, your lordship got it.
Yes, yes.
With effect on so and so per month, so and so. Again, the period of suspension.
Well, what
of
was
the-
this earlier writ petition 4231?
That is for disposal of the disciplinary proceeding. That your lordship will get it at page 51. The relevant part, the disciplinary proceedings to be concluded within an outer period of 45 days. As your lordship.
Order is dated 1/7.
Yes. Our main ground of attack was, mainly, there was no charge sheet, no list of documents, in total violation of Rule 9.
But the court did not accept that. Court asked the
No,
proceeding.
yes, naturally, because the discipline proceeding was not concluded,
Yes.
so it was, I have no given.
Okay.
So
Thereafter,
in the appeal, they have filed this order, my lord. They have reduced it,
page.
page 59. He got relief, more or less, but this
59.
59, 9 March 2022.
Yes.
Relevant, your lordship will get it at page 61. So demotion has gone. It is in Rule 9. Censure, treating this period of suspension from so and so as leave. So this is done without any notice to me.
Which is done.
This order has been passed considering my appeal, but for the purpose of censure, that FR 54 has to be followed. And for the purpose of my lord, treating this
Censure of
suspension.
the initial penalty, one of the penalties in,
Yes, one of
and
the
censure
penalties-
has not been touched. So
Censure has not been done. Therefore, I have come here. And that treating this period of suspension from so and so,
as leave.
specifically, they will have to give reason, notice, my lord, that treating his period of suspension from 19/5/20 to 26/7/21 as leave as per revised leave rules 1934, as adjustable from the available leave at his credit as per the revised leave rules 1934. In para 13, we have stated, my lord, annual increment for the post of head assistant has not been given. This is one of the ground, I have, not ground, my lord, I have said, my lord, one of the grievance.
Annual increment,
Increment for the post of headmaster, head assistant has not been provided for the year 2020 and 2021. That I have stated in para 13.
from, please kindly repeat the date and for the period 2020.
2020 and 2021. Although penalty of reduction from post of head assistant has been withdrawn.
Okay.
Your lordship.
Okay.
Now, rule 9, your lordship will kindly.
Of these,
Rule, some disciplinary and civil appeal rule,
64 rules.
64 rule. What of the rule 9? Right. Now we go to 9/12. Your lordship will see the records, my lord, how they have imposed the penalties. No charge sheet, nothing is there, my lord. Total violation of rule 9. Rule 9/12, my lord. For the 11/12. Sub rule 12 of rule 9,
Yes.
B.
Hmm.
12A, if I read, my lord, notwithstanding anything contained in this rule, it shall not be necessary to follow the procedure laid down in the proceedings. Sub-rules in cases where it appears to be to the authority competent to impose the penalty at the initial stage of the proceedings, that the penalty of censure would be adequate. That is only if you say that only penalty. But if at any stage, any later stage, that is after DP and all, my lord, it is proposed to impose any other penalty specified in Rule 7, the procedure laid down in the said rules shall be followed. Now, B, no order imposing the penalty of censure shall however be passed except after the government servant is informed in writing of the proposal to take action against him and of the allegations on which it is proposed to be taken, and given an opportunity to make any representation he may wish to make any. Such representation, if any, is taken into consideration by the disciplinary authority. Now, on this, my lord, I will place one judgment. 1989 Lab, my lord, IC 705. This one? It is a conservative. So, dear man. Paragraph 8 will do. Dambodhar Pathak was the author, my lord.
You are placing CAT judgment.
My lord.
CAT judgment. CAT
No,
judgment.
lab. It's cat judgment.
Sorry,
Because
sorry, we will not take CAT
on
judgment.
this, my lord, only
Sorry.
one judgments are there.
You
This
place
is based on-
anything. Don't place CAT judgment before us.
No. No, 54B, your lord.
Of the FR.
Yeah, sir. What? This is based on 54B only. It's all 850.
54.
54B.
Yes.
54B, my lord. 1B. B. 5.
1B.
B. 5. In cases other than
No, this is not 1B5. This is 54B5.
B.
5. Not 1B5. 54B5.
B5. ma'am. B2. Yes, B5.
B5.
In cases
In
other than,
cases.
yes,
In cases.
in cases other than those falling under sub-rule 2 and 3, the government servant shall, subject to the provisions of sub-rule 1, 8 and 9, be paid such proportion of the full pay and allowances to which he would have been entitled had he not been suspended, as the government authority may determine after giving notice to the government servant of the quantum proposed and after considering the representation, if any, submitted by him in that connection within such period, which in no case shall exceed 60 days from the date of the notice, which has been served as may be specified.
In cases where, in cases other than those following out 2 and 3, government servants shall, subject to 8 and 9, be paid such proportion.
The notice is a must, my lord. The notice has to be given specifically.
To which is entitled.
This is regarding, my lord, treating the period as spent on duty on that one. I'm sorry, my lord. This is for, my lord, for purpose of treating the period of suspension. I'm sorry, my lord, I have gone there. Rule 9, 12, 2.
Suspension, yes. But
Rule 9, 12, I have you.
Mr. Das, this 54B5 which you have just placed,
Yes,
those that 5 is subject to many other sub rules 2,
Yes.
3, 8, 9.
yes. Your lordship will read that, my lord, it will not go through that. Because 54B, my lord, Roman, small letter B, your lordship will kindly see whether or not the said period shall be treated as a period spent on duty. Then your lordship will kindly see rule 5. 54B5.
Hmm.
When a 54B, my lord, when a government servant who has been suspended is reinstated or would have been so reinstated, but for his retirement or superannuation while under suspension, the authority competent to order reinstatement shall consider and make a specific order, B, my lord, whether or not the said period shall be treated as a period spent on duty. Then 5. After giving notice to the government servant of the quantum proposed and after considering the representation event.
Okay.
Rule की what बोले? Rule 8 year तक. The Lord will kindly read 8, 9 out. Sub rule 8 and 9.
Hmm.
That before stating the period of their notice specifically has to be given to the concerned honored employee. This is what it means. In this case, it has not been done. And sub rule 8 and 9, your Lord will kindly see. This is not relating to the notice part. Payment of allowances under shall be subject to all conditions under which such allowances are admissible in the proportion. 8 and 9 is there only. Well, B. Consider that. Very good. Very good. Consider. Well, B. Topic 11, 12. A, B.
This is other than those following on.
APK. No.
But this you have relied upon 5. But if you read 54 1 small b,
54.
54b small 1b,
1B,
1B.
54B, 1B, yes.
1b. First, let us read 54b1, the
Yes.
heading. When a government servant
Servant
who has been suspended is reinstated or would have been reinstated but for his retirement on subordination while under suspension, the authority competent to order reinstatement shall consider and make a specific order number B,
Whether or not, yes,
whether or not the
No.
said period shall be treated as a period spent on duty.
dude.
It is
But
the
for the purpose of putting that 5 will come.
no 5. That is why they have the prerogative to pass an order whether the period should be treated as spent on duty or not.
Yes.
Now 5 says that if they hold you to be entitled to a certain portion or the entire amount, they will put you to notice.
Notice has to be given.
If they decide
Yes.
that certain portion of the full pay will be paid to you, only
Yes.
then. If you are held to be without, not on duty, then
If,
if 54(1) small b is made applicable, where is the scope to apply 5?
whether or not the state period shall be treated as a period spent on duty, then your lordship will kindly see. In cases other than those falling under sub-rule 2 and 3, the government shall, subject to provisions of sub-rule 8 and 9, be paid such proportion of the full pay and allowances to which he would have been entitled had he not been suspended, as the competent authority may determine after giving notice to the government servant of the quantum proposed and after considering the representation if any.
And kindly read 9 also. 9 is subject to 9.
9.
Yes.
The proportion of the full pay and allowances determined under the proviso to sub-rule 3
Or under
or
sub
under
5
rule 5 shall
shall not be less than the
subsistence
subsistence allowance.
allowance and other allowances admissible under rule 53.
So the guarantee given is that you will not get less than what is the subsistence allowance.
Yes.
If you
But here, my lord, what has been done? His leave has been, my lord. Period of suspension from so and so will be treated as leave at his credit. For a particular period, that suspension period will be treated as leave at his credit. So his leave goes, my lord. And for the purpose of treating that leave, one has to be given specifically a notice that why your leave should not be treated as, my lord, as leave at his credit. The notice has to be given. My lord, your lordship will kindly see this whole disciplinary proceedings was initiated, my lord, without giving any charge sheet and without your lordship will see the records. And no, my lord, records were produced before the were given to the petition.
But that
So-
aspect, can we go now?
Yeah, my lord, because
When
of,
you had
because
come to
of
the
this
court-
54(5), my lord.
You had come to the court earlier. That was not even the
No,
order.
earlier we came, earlier, my lord, court said, my lord, you dispose of the appeal.
No, not the appeal, disciplinary proceeding.
Disciplinary proceedings first, then thereafter, my lord, appeal. 2 writ petitions were passed. One is page 44.
Yes. Come to page 51.
Yes,
51,
51.
A, B, C, D.
Yes.
Disciplinary proceeding be concluded within an outer.
period of
We
45
cannot
days.
go back to the aspect of the legality of the whether charge sheet was given or not.
No, because, my lord, disciplinary proceeding itself, we have questioned that charge sheet was not given and it is in violation of the rule. So court said you dispose of the disciplinary proceeding while my lord, considering the disciplinary proceedings, one has to take into consideration that whether charge sheet, whether rule.
What
9
was
has
the
been
subject
followed.
matter of challenge in the earlier writ petition?
Subject matter of challenge that disciplinary proceedings is pending. And therefore, it has
If
to
that
be,
was the
because it
subject
was not
matter.
concluded. It was not concluded. So naturally, we'll have to ask for the conclusion of the disciplinary proceeding. And second, my lord,
We cannot go back. If that was not the matter of interference by the court while disposing the earlier
Well,
writ petition on 1/7/2021.
this order, which your lordship will get it at page 44.
Yes.
It is basically, my lord, disciplinary proceedings is pending, so it has to be disposed of.
Yes.
So it has to
You
be
are not
disposed
agree,
of.
you are not aggrieved by the initiation of the proceeding.
We are not agreed because
Then-
the disciplinary proceedings as initiated, we have taken a question
Yeah,
there.
you can definitely challenge the order of penalty that it is on various grounds.
Yes.
But we cannot go back that charge sheet was not given to you, no notice was given to you.
But
We
that
cannot
is the
go back to
crux of
the
the matter before the disciplinary proceeding. Because therefore
You read paragraph 3 of page 44.
yes, I'm reading it.
The entire history is there. Those were matters of consideration in the first round of litigation. We cannot
No,
reopen
no,
it.
Those were taken into consideration, but ultimately court directed, and we are not agreed by it. Court directed you dispose of the disciplinary proceeding,
They have
whatever is
disposed of.
there.
After
Well,
disposal, you
court did not look into the merits of the subject matter. Dispose of the disciplinary proceeding, page 51.
You can challenge the disposal part, but not on the ground that show cause was not given to you. That was could have been the subject matter of the initiator. How could you initiate a proceeding without a show cause?
No,
The
my
court
lord,
has not even entered into. Court said that you finish up the proceeding. You challenge the order of penalty. That's a different matter. We are
So therefore, my lord, when the my lord, disciplinary proceedings was disposed of, my lord, we filed an appeal.
Hmm.
Same ground is there, and in the appeal, my lord, that my lord, this penalty was imposed, removing the major penalty of demoting him from the head assistant to the UDA. So that was issued because, my lord, the main ground was that also, that you have not given any proper charge sheet rule in violation of the Rule 9. So that was measured. Now, ultimately, my lord, they have given these two my lord, penalties of treating the period of suspension from 2022 to 2021. That is,
But then how do you overcome the observation of the court in C? Page 51C.
see, yes, it is needless to mention that in order to complete the disciplinary proceedings, see, my lord, if
See.
the disciplinary proceedings against the petitioner cannot be concluded within the allowed period of 45 days, the respondents are directed to pass appropriate order to reinstate the petitioner in service with full salary and allowance.
Please read further.
However, it would be open to the respondents to treat the petitioner on
leave.
Leave, my lord, pending departmental proceeding. This is a different aspect of the matter. To wit, entitlement to full salary till logical conclusion. If the disciplinary proceedings is not concluded within a period of 45 days, he is entitled to be reinstated in service. This is what it is. It did not
When was the reinstatement done?
reinstatement done because we filed appeal, and in appeal this.
No, there was never a removal from service.
No,
So
demotion
there,
was there.
no.
He was
The question
demoted.
of reinstatement is not there.
Okay.
You are always there in service.
I'm always there in service, but as UD.
Appellate authority has omitted that part of the penalty whereby your rank was reduced.
Reduced. That has been removed now in appeal.
Okay.
So, but while doing so, my lord, they have not followed the provisions of law.
See, this order was passed, page 51 order was passed on 1/7/2021,
Yes,
when even the first order of penalty was not there,
at the, because disciplinary proceeding was
was
not.
not even concluded.
Not
So we cannot go to the aspect of appeal, what has happened in the appeal.
That's all right, my lord, but
So that reinstatement would be where? In the original post, which have now
in terms of the.
when were you reinstated? When was
not
the
reinstated,
suspension?
He is already, he is
No, when was
already-
the suspension were revoked?
suspension was revoked. I'll show my lord. That I'll come with. 52. Page 52. Can I? 26/7, my lord, 21.
No, that is the order of the appellate authority,
Yes,
page 52.
and thereby he was, my lord, reinstated in service. He reinstated as head assistant, but otherwise, my lord, he was continuing at the UDA in terms of the earlier order.
Yes.
Now, second aspect of the matter, your lordship will kindly say, rule 12, rule 9(12) B, which I have already read.
Yes.
12B, my lord. So, 112. No order imposing the penalty of censure shall however be passed except after the government servant is informed in writing of the proposal to take action against him and of the allegations on which it is proposed to be taken and given an opportunity to make any representation he may wish to make. This I have already read, my lord. For the purpose of censure also, appropriate writing has to be there, that why your the penalty of censure shall not be put. That is not there.
No, Mr. Das, reading that will not do.
Yes.
See, minor penalties are there
Seven.
in 7,
Yes.
which includes censure as the first penalty.
Yes.
Now, to impose the penalty of censure,
Censure.
you may take recourse of a disciplinary proceeding.
Not
Under 11,
disciplinary
11,
proceeding.
11
Yes.
first.
Yes.
Now, 12 says that notwithstanding anything contained in this rule, it shall not be necessary to follow the procedure. So, for censure, it may not be necessary to have a full-fledged disciplinary inquiry.
Not full-fledged.
Not full
Just a notice.
notice, but here they have had a proceeding. Not
No.
only censure, you are reduced. So, can you go
No,
back to the aspect that
that is-
notice was not given?
That disciplinary proceedings on different ground. Your lordship will kindly see disciplinary proceeding. How they page 32, my lord,
Yes. 3-2.
32.
Yes.
You are hereby required to show cause under Rule 9
Hmm.
of the so and so rules why any of the penalties prescribed in Rule 7
Hmm.
of the aforesaid rules should not be inflicted on you on the following charges. While you were serving as head assistant PW, so and so, all these charges are there. There is nothing that why penalty of censure shall not be put.
No, it's not necessary.
No, it is necessary.
not
my lord.
necessary.
As per Rule 12, if you want to put a
We may
penalty of
not agree, we
censure,
may not agree with this proposition.
my lord, your lordship.
See, kindly read 11.
Yes.
A minor penalty can be given after a full-fledged disciplinary proceeding. If they do not, if they are on the intention that we are going to impose censure, then even full-fledged disciplinary proceeding may not be required, but notice would be required. Here, you have been given all the opportunity. 11, it's a proceeding under 11.
No, but for the purpose of putting a person on censure, simple, you don't have to go for.
You may not, it's
disciplinary
their
At the
prerogative.
first stage.
Mr. Das, what punishment they'll impose at the initiation of the proceeding, it is not known.
Not known.
If they are under the impression that we are going to impose a penalty of censure,
Yes.
then a full-fledged disciplinary proceeding may not be necessary. A notice would be enough.
Yes, notice.
But here a proceeding has been done,
But
giving you
this-
full
that
opportunity.
proceeding is relating to a different thing. It is not relating to censure at all.
No, censure is the penalty. Censure is not the
Penalty,
charge.
penalty.
Censure is the penalty.
No, that is
One of the penalty, and the
but
7-1.
specifically that, as per my understanding, my lord, specifically a notice has to go why censure shall not be.
That will be, you may be correct when they are under with the impression that we are not going to hold a full-fledged inquiry. We are going to impose censure upon you. What is your take? That is all. Here it's not the case. Here the charges was of corruption. And in fact, initial penalty, other than censure, there was another penalty.
My submission is that, my lord, that disciplinary proceeding. After the disciplinary proceedings, if they wanted to put the censure, that notice should have been given specific. And in terms of 54B also, my lord, that for the purpose of treating the period of suspension from 19/5/20 to 26/7/21, that 54 capital B 1 small b, my lord, 5, a notice required. Rule 90 capital. Rule 90 capital. Rule 90.
Okay.
And for the purpose of Rule 111, if the disciplinary authority wants to impose the penalty of censure and the penalty of
Reduction.
that suspension, treating the period of suspension, then in that case, your lordship will have to see whether the disciplinary proceedings has been concluded in terms of Rule 9. In terms of Rule 9, your lordship will kindly see. On that also. Rule 9 to cut it. Huh? Procedure for imposing penalty. So this procedure has to be put. It is not that, my lord, for the purpose of censure, you can, my lord, bypass the disciplinary proceedings in terms of Rule 9. So I have specifically stated, my lord, that they have done it in violation of the Rule 9. Without prejudice to the provisions of Public Service Inquiry Act 1985, no order imposing on government servant any of the penalties specified in rule shall be imposed except after an inquiry held as far as may be in the manner herein. The disciplinary authority shall frame definite charges on the basis of the allegations on which the inquiry is proposed to be held. Such charges together with a statement of allegation, these are not there, no statement of allegation on which they are based shall be communicated in writing to the government servant, and he shall be required to submit within such time. This statement of allegation, list of witnesses, nothing is there. The lordship will see the record. So in that case, my lord, if they want to put the censure and the suspension period, my lord, they will have to follow the, my lord, provisions of Rule 9. So this has not been done in this case. So on that ground itself, this is liable to be satisfied. Your lordship will see the records, my lord, whether they have followed the procedure laid down in Rule 9. My Para 9 has stated, my lord, no charge sheet has been given without giving any charge sheet as well as inquiry report to the petitioner. Even the inquiry report was also not given. And also without you, where is the inquiry report? And also without giving any opportunities of cross-examining any of the
You were
witnesses.
earlier also
Para nine.
penalized.
Para 9.
Even earlier occasion you were penalized.
Earlier occasions, my lord.
Suspended in 2000, 2013, 2020.
Yes, these are there, my lord.
Penalized, one increment,
But
censure.
those are gone, my lord. There some action was taken again, he was placed under reinstated himself.
Okay. Yes, Mr.
My submission is, my lord, disciplinary proceedings, the rule has been followed or not, whether inquiry report has been given, charge sheet has been given properly, and whether list of witnesses, all these provisions of Rule 9 has been followed or not. The lordship will kindly see the record and take it. Because if censure and this period of suspension to be treated on leave is based on the proceedings of the disciplinary proceeding, then your lordship will see whether the rule has been followed.
Okay.
Otherwise, my lord, that will not come as your lordship has said. That if the disciplinary proceeding has been concluded on the basis of the disciplinary proceeding, one can pass the order penalty of censure. But in that case, your lordship will have to see whether the procedure laid down in Rule 9 is there.
Yes, Mr. Dhar.
Well-
Yeah, for PWD. PWD. Okay.
My lord, I have gone through the record, my lord. He was given a show cause notice on 20 regarding the proceeding 25/2020,
25.
20/05/2020 with statement of allegation, my lord. It is attached there. It is there. Statement of allegation and my lord charge was framed, my lord. It is there. Then my lord, so it is not that my lord, he was not given a show cause notice, my lord, and charges were not framed, my lord. It was framed. Statement of allegation was also there. And my lord, ultimately it concluded. But my lord, the interesting thing is that, my lord, in between he came before this honorable court. The honorable court has disposed of with the direction to dispose the DP, my lord. That was concluded, my lord. Thereafter again, he filed a appeal, my lord. In that appeal also, my lord, that challenging that censure, my lord, order. In there also, we have given on 28/12/2021, we have given him a show cause notice. In that also, my lord, he has filed an appeal. So it is not that, my lord, he was not hard. He was hard, my lord. He was given every opportunity, my lord, to place his case.
Appellate court heard him.
My lord.
Appellate authority.
Notice is there, my lord. 28/12. I can place this, my lord, before your lordship. Notice was there, my lord. And ultimately that order was passed, my lord. That appellate order, my lord, dated 9 March 22. Appeal order. So, my lord, here what has fallen from my lord mouth, my lord, that censure, my lord, this is the outcome of the DP, my lord. So, my lord, we never knew when we started the DP, my lord, we did not set a mind that we will, at day one, that we will give him that. It was a on pure DP, we proceeded, and ultimately, my lord, in our own wisdom, we found that this is the punishment that has to be imposed. So that is what we have imposed, my lord, nothing more. And for that, my lord, before imposing a punishment, I don't think so, my lord, that we need to give him a notice that we are going to give you this punishment. So what you have to say. That is all, my lord. It is not that you are not hard, and this is just for my lord's perusal, that 28/12/21 before the appeal.
What about the second leg of argument that treating the period of suspension? See, appellate authority has interfered with the second punishment of reduction.
My
But
lord.
at the same time, censure has been upheld,
Yes,
which is one of the subject matter of challenge.
My lord.
And secondly, treating that period of suspension. How have
My
you
lord.
treated that? You have treated that he is on leave from his leave credit.
My lord, if you go by the this order dated 9th March 22, the appeal order, my lord.
Hmm.
In the second page,
Page 59.
page 59, my lord. I'm just reading the record, my lord. Okay, my lord. Yes, 59, my lord.
Hmm.
My lord will come to page 60, the last paragraph.
60.
60, my lord. Here, my lord, the department has taken a, my lord, a soft stand on him. That is why, my lord, we have let him off, my lord. It reflects, my lord. The last paragraph. At the time of hearing, on 7/3/2022, Sri Devjit Debray submitted his prayer petition and request to withdraw and quash major and minor penalty as imposed against him by additional chief engineer such and such order dated such and such on 27/7/21. Devjit Debray also stated in his prayer petition that he have only 4 years remaining service and he is getting trouble in all respect along with studies of his children and prevalent request to reinstate him as head assistant with all back wages and also treat the period of suspension from this 19/5/2022, the order of penalty as on duty. So, my lord, this aspect, my lord, our officer has taken into consideration in the appellate authority, my lord. After careful examination of the above document furnished during hearing by additional chief engineer such and Sri Devjit Debray senior assistant involved in the indisciplined activities, violating official decorum, expressing insubordination to his superior officer, breaking solidarity among the staff and administrative head office. However, considering Debray's submission that his indisciplinary rude behavior were unintentional, that he has only 4 years left to retirement, that he will not repeat the undesired behavior and action, that he will work with desired commitment and relying on good faith, it is decided to limit the action on him on the following. So, my lord, this is the thing, my lord. So, my lord, the department has taken a lenient view on his prayer and taking a view that, my lord, he has only 4 years left, he has children, education, all these things, my lord. The department has gone soft on him.
Increment, there is one issue which is not directly the matter of challenge. He has not been given the increment. You have to give the increment. And in the affidavit, you have said that the increment part, you are the
Yes, my lord.
process is on.
The process of sanction increment, that is, yes, my lord. That is there. We have left open.
But you have
my lord.
not addressed the main two grounds in the affidavit. You have argued that censure, when it is an outcome after a disciplinary proceeding,
My-
the question of notice separately will not come.
My-
Notice would come only when you do not hold the disciplinary proceeding. You think that will impose censure notice before
my-
that.
yes,
That's a
my-
different aspect. We have
acceptable.
understood that.
Acceptable.
But there are other legs of argument also, Mr. Das. He says, how have you treated the period of suspension?
My lord, sorry, my lord. My lord, disciplinary proceedings they have initiated. There must be an inquiry officer. Inquiry officer must call me. There must be an inquiry report. Where are all those? That your lordship will kindly see page 60.
60.
60. This is the impugn order passed in appeal. Starts from page 59. That is why the record was called for. page 60. As such, inquiry report regarding departmental proceedings against Sri, where is that report? I don't have. Sri Roy, head assistant, was forwarded to the commissioner, not to me, and special secretary to the government of Assam for approval of punishment recommended thereof. What is this
Now we'll
proceeding?
see the records.
Your lordship will see the
We'll see
records.
the record.
It is in total violation of rule 9, 4, 5, 6, and 7. This is what my case is.
Yes, Mr. Dhar.
Fine.
Kindly place the records and kindly flag mark it.
See one part, your lordship, inquiry report, whether it has been given to.
Yes, records.
My lord, whatever I have, my lord, I have flagged everything, my lord, and I have written, my lord, what is there.
You have not even verified paragraph 18, Mr. Das. Paragraph 18 is the only submission you have. We have searched. 18 has not even been verified.
Paragraph 18 minutes.
Except 18, there is nothing.
Submission only.
You have not even verified. You can submission. It's not even a statement by you.
Submission will be, my lord.
It's not even a statement. Matter of fact cannot be a submission. If you are saying the show cause notice was not
And the
given,
rest are my humble submission before the.
submission how can be a statement?
No,
If show cause
statement is
was not
paragraph
given,
9, no.
where is paragraph?
Paragraph
9. This is regarding the appeal, not your
Without
statement.
giving any option to cross-examine. I've stated that the penalty was imposed without giving any
This
charge
was
sheet
the,
as well
this was the
as well
statement,
as inquiry report.
this is a statement with regard to filing of the appeal.
Say that being agreed by the said order of penalty dated 26/7/21, the petitioner preferred an appeal on
Appeal,
so and so
yes.
before the, so same ground is available here.
No, where?
On the ground, my lord, this is the ground I have taken, this ground in the appeal I have taken, so I'm challenging the order of appeal. My lord, ultimately, my lord, this petitioner is entitled to get a copy of the inquiry report.
Let us see. Yes, how did you conduct the inquiry?
Your lordship will see whether there is any fairness. Second show cause where the second inquiry report was given to me. In a fantastic manner, my lord, what I find, my lord, in the absence of the fantastic manner they have conducted an inquiry. Inquiry report has been sent to the higher officer. Then thereafter the penalty is. Even inquiry report has not been given.
That part, man, whether inquiry report was given, I cannot verify from the record. Man.
Their affidavit is there no comments in regard to paragraph 9.
This is not the records of the inquiry. We want to have the records of these are record, correspondence with the council and the department, few papers.
My lord, this is what they have stated. Some time ago.
This is not the records. Mr. Das is making a very serious, raising a very serious issue that
I understand.
the penalty was imposed even if we are giving, holding a proper inquiry under section 9, under rule 9.
Then
We have seen a show cause notice, but the show cause notice which the petitioner has enclosed, that does not, it is not accompanied by a list of documents or witness. There is another show cause notice with an additional allegations. That has the list of witness and list of documents. Thereafter, how was the inquiry held? Where are the proceedings of the inquiry? These are not the inquiry proceedings.
I don't keep it part. I let us start it. I will. I'll try to.
Take help, get the records. Get the records.
Blame is, my lord. Mr. Or, my lord,
But even in your affidavit, you have not said anything.
nothing. my lord. They do not advise their clients properly.
Heard Sri B.D. Das, senior counsel for the petitioner at some length. Three, Arthur Leonard, standing counsel PWD, has produced a file of the department. What's the however perusal of the same? Does not disclose that the records of the inquiry proceeding are available in this file. Para. The standing counsel of the department accordingly prays for and is granted some time to obtain the records of the inquiry. Para, list on.
Any date. It's from Dispur only taken.
No, my lord, it has to come to Borak bill.
Correct. DP was conducted here, my lord.
And your report will be from there.
List on. Today is what? 27. Can we have it on 17th?
My
Oh,
lord.
17th you get sufficient
My
time.
lord.
17th.
Fine.
Is it okay, Mr. Das?
9 months.
17/9, Tuesday.
Will remain as part of.
We have said at some length, we have said.
Right.
We have given sufficient time, bring the records. In fact, hearing is almost over.
Lordship,
Yes, Mr.
with
Anand?
regard to item number
Yes,
2,
yes, Mr.
I
Bourne.
called up Ori Burman,
Yes.
but she left her mobile at home and went out somewhere. I also looked up,
Madam walked.
I also looked for her here. She is not available in the court
As
today.
walked.
Walked, I did not find him. He is not
Marjorie.
available in the court.
Narjari,
I have to look for them.
try
Not
to
to fix it on Thursday.
Thursday.
I'll
Please.
call up in the evening and
Yes.
tell her that.
Yes. Item number
Item 2.
Do Sri Mannan, the learned counsel for the petitioner is present, comma. None appears for the respondent was 225. Of course, the cause list, however, reflects the name of the learned counsel for the said respondent was 225. Para, in the interest of justice, the consideration is deferred till Thursday next.
Okay.
List on Thursday, huh?
Okay.
Date to be. Thursday, also Tuesday, no? No, परसों. Yes, my partner.
My lord, the
Item number?
issue pertains to promote.
Item number?
Item number 6, my lord.
Yes.
Issue, my lord, pertains to promotion of dental officers in the Assam Rifles, my lord. These are doctors who are appointed, my lord, in the Assam Rifles through a recruitment rule of 2010, my lord. The core issue, my lord, that we have raised is that the promotional criteria that was prescribed in the recruitment rule, my lord, I had fulfilled the same, and therefore my promotion was to be considered. The Assam Rifles stand is that no further course, which is not mentioned in the recruitment rules, is also to be completed as a prerequisite qualification criteria. As to how, my lord, that further instruction on the recruitment rule had come, my lord, is not clear from the affidavit of the Assam Rifles.
But if you are required to have a additional degree, higher degree for promotion,
Not higher degree, further training, my lord. Yes. The recruitment rule
if you do not,
initially says,
if you have not undergone the training,
my lord,
and is stipulation of a or provision of a training, is it bad in law? It's not unreasonable. If you are holding if
My
you are aspiring to hold a higher post,
Well.
and if there's a prescription of having a specialized training,
Well.
We don't think that is
my lord,
unreasonable.
that I don't have any objection as to that prescription.
Hmm.
The recruitment rule says that I need to complete the basic computerization training, which was already completed. Later on, they say that there is also a course which is called the MOBC, that is Medical Officers Basic Course, which is also required to be completed.
Hmm.
My lord, as to how this course was introduced as a prerequisite for promotion, my lord, on what instruction, that has not come forth from the Assam Rifles, firstly. Because a recruitment rule or a policy cannot be introduced by word of mouth, my lord. There has to be some instruction.
No,
There
that
has to be
definitely
some
will
time.
have. Yes, madam.
And the second issue, my lord, just one more point, my lord. The second issue is that there was also in the 2010 recruitment rule a junior senior clause saying that if my junior is promoted, in that case, my lord, my case is also to be considered if I fall within a period of 2 years from his date of, my lord.
But if you do not fulfill this MOBC, then
Yes.
My lord, that is for the first promotion that was due to me. The second promotion that was due to me, my lord, at that point of time, I had also done the MOBC.
Okay.
At that point of time, also this junior clause had come in. They say that in 2019, the Ministry of Health and Family Welfare introduced a rule in which the junior senior clause was taken away, as was provided for in the 2010 Assam Rifle rule. My lord, but then their own affidavit says that clarification was sought for as to whether this 2019 rules is applicable also to the Ministry of Home Affairs, which controls the paramilitary forces matter. On that, there is no clarity as of now.
yes,
my lord.
madam.
Yes, for past issue lordship, he was appointed on 29 February 2010. After that, he is eligible for promotion on 29 November 2014. As per the Assam Rifles rule, which I have annexed on as Annexer J, page 64 from
Yes.
on 66, it is here it is mentioned that from amongst the dental surgeon, assistant commandant dental, on completion of 4 years of service in the grade and being in medical category, step 1, and on completion of basic compassionate training. Here he has completed 4 years, but he does not complete the MOBC training. And that he mentioned that he has got that undergone that training on that is on 6/12/2010 to 2012/2010. But that was not that was not required for the that is not for only for familiarize the person who come in the Air Force for that training. It is not here. I have another annexer is there where it is on page 74. Clarification is also there. Here it is says that point number 5.
Yes. Yes.
Here it is says that reference this branch letter number so and so dated 28 February 2010, 18. Previous has also clarified that training program undergone by so and so Deputy Commandant Suman, that is on 2010 to 6 December 2010 to 20 December 2010 cannot be equated as mandatory for promotion to the rank of Deputy Commandant Senior Dental Surgeon as prescribed in recruitment rules. The subject training was only a familiarization course.
Oh, no, Madam, he's not on this aspect. He's saying where is the prescription of the rules which requires undergoing of a medical officer's basic course? You show us that.
Here it is on completion of 4 years of service. He completed after completion of service. He was detailed for MOBC effect from 23/1/2014 to 26/3/2014. But he has refuses to. He expresses unwillingness because of he gave a birth to a child.
No, where is the requirement to undergo MOBC?
That is mentioned in the Assam Rifle Rules of Lordship.
Show us.
Yes,
Page.
that is I have annexed on Annexer J,
Page
page 64. That is I have read
64.
here 12 number 12.
64 is the notification.
66
No, the
rule, Assam Rifle
hello.
Rule.
notification starts at 64.
Yes,
This is the recruitment rule, ma'am.
Yes.
this is the recruitment rule 66, the page number, and last paragraph.
Just a
From
minute, please.
above-
Just a minute, please. Recruitment rules. At 66.
Yes, page 66.
Hmm.
Last paragraph.
Yes.
Point 12
Yes.
here, left side.
Yes.
From amongst the dental surgeon, assistant commandant dental on completion of 4 years of service in the grade and being in medical category step 1 and on completion of basic compassionate training. He does not complete it.
Or there is a
Yes.
requirement to complete basic competition training.
Training. Yes, sir.
Yes, there is a prescription.
My lord,
And your initial entry, that was only a familiarization course, not.
my lord, my entry, initially my appointment letter says annexer 1 of page 19.
19.
Page 19, annexer 1 in my.
19.
My lord.
Yes.
My initial posting order says that I am posted after completion of basic military training.
Basic. No, that's a different matter.
My lord. MOBC is not a competization course, my lord. MOBC is a course they introduce
What is
subsequently.
this basic MIL means? Military.
Military training. Military, my lord, same as competization, my lord. Because everybody is competizing in Assam Rifles.
No, are others who are promoted, they have not gone through this course.
Yeah, they have gone through the course.
There is a prescription in the rules.
My lord, the rule
This
says competization.
initial entry, completion of basic military training is a different matter.
My lord.
And when they have prescribed that for being considered for promotion, you need to undergo another basic course.
My lord. My lord, where is the prescription, my lord?
There's rules.
The rule says only basic competition training.
Yes.
Yes, after completion of 4 years.
Basic competition training is the initial entry, my lord, because everybody who has to, my lord, enter into a paramilitary force have to be competized, and therefore they undergo a basic military course to begin with. Thereafter, only appointments can happen. And MOBC is the course, my lord, of course, they can introduce subsequently in supplementing the provisions of the recruitment rule. But then there has to be instruction saying that the promotional criteria is also now that you have to complete a further course of MOBC to be considered for promotion. There was no specific instruction as such. And the second aspect, my lord, their affidavit itself, if your lordship comes to the page 76, my lord, of their affidavit, the last page of their affidavit. This aspect also remains unaddressed because they say
76,
76, my lord.
Yes, please.
76. This was in processing and considering my case, my lord, queries were made to the Ministry of Home Affairs by the Assam Rifles. There were two specific queries. The first query, my lord, was, is the recruitment rule for dental post 2019 applicable only for Ministry of Health and Family Welfare?
Where are you reading?
My lord, I am reading page 76 of the affidavit filed by the respondents.
Annexure,
It would be annexure O,
annexure,
LMNO.
page 76.
Annexure O starts from page 75
Oh,
of 24 November 2020.
then, okay, see, which 76, which part?
76, my lord, clause C,
Hmm.
1.
Hmm.
So in 2019, as I said, my lord, the Ministry of Health and Family Welfare introduced the rules for dental officers, my lord. So the query was made that whether this rule was or is applicable also to the MHA, my lord. Because this particular rule, my lord, this junior senior clause is not there. So even if my initial promotion to the rank of deputy commandant is after completion of MOBC,
When did you complete MOBC?
MOBC was in February 2016,
You had completed.
my lord. And thereafter, my lord, promotion was affected.
For 2 times, he has rejected that.
No, the rejection was, my lord, due to circumstances that the lady was pregnant and delivered a child and she was on child care leave. So it's not
But you had
rejection as
completed in February 2016.
60.
Thereafter,
My lord, the promotion came on 2nd June 2016.
promoted to the rank of?
Deputy commandant.
Okay. Now the second grievance, what is the senior junior? What is
The seniority, my lord, it says that if your lordship reads that particular clause, this in the affidavit only, page 66, lordship was reading.
Yes.
See,
66.
my lord, page 66. Where juniors who have completed their qualifying or eligibility service are being considered for promotion, their seniors would also be considered
66,
provided.
which part?
66, my lord, this column 12,
12.
where the prescription.
Oh, note.
My lord,
Note.
the
Okay.
note.
Yes.
Where juniors who have completed their qualifying or eligibility service are being considered for promotion, their seniors would also be considered provided they are not short of the requisite qualifying or eligibility service by more than half of such qualifying eligibility service or 2 years, whichever is less, and have successfully completed their probation period for promotion to the next higher grade along with juniors who have already completed the qualifying or eligibility service. Now this note, my lord, that is there in the 2019 rules of the Ministry of Home Affairs, sorry, my lord, the Health and Family Welfare, this clause was removed. So whether that Ministry of Health and Family Welfare's rule is applicable to not or not, my lord, to the Assam Rifles, was a query that my lord was made in 2020 when I had referred my lord in page 76. This query was made. So if this relaxation is not there, my subsequent promotion, my lord, ought to be considered in 2019 from 2016. Because 2 years relaxation I would get if my juniors who got promoted in 2014 because I had not done the MOBC course. In the promotion that comes subsequent to the rank of OIC, since my juniors are getting promoted, my lord, I have to be considered in respect of the 2010 rules. The effect of it, my lord, is vague because they say that the 2019 rules is also applicable to Assam Rifles, but then the query itself shows that the ministry has not clarified if 2019 rules have replaced the 2010 rules of Assam Rifles. Unless
2019,
and only there's some clarity on this issue from the Assam Rifle, my lord, might be difficult because recruitment rules cannot be changed by affidavit, my lord. There has to be some positive instructions as to adoption of particular rules and criteria, my lord. There has to be notifications. Where are those notifications, my lord? If I don't
no,
follow
see, you have read part of the notification, original notification 2010.
my lord,
2010, at page 66, there is the prescription
my lord,
for promotion, wherein under the note, there is also a provision regarding juniors and seniors,
my lord.
where juniors who have completed their qualifying or eligibility service are being considered, their seniors will also be considered. Provided what? Provided they are also not short of the requisite qualifying or eligibility service by more than half of such qualifying or eligibility service, or 2 years, whichever is less.
Okay.
After you have completed the training,
My lord.
where junior is considered.
My lord, because the 2IC promotion, it came into effect in, my lord, 2019. Those who were in the batch of 2014, they got promoted in 2019. In 2019, my 2IC promotion ought to have been considered also. There's a representation to that effect.
See, you are
They
promoted
now
to the
refer to the 2019 rule saying that this junior senior clause was not there. When I represented, I asked the ministry for clarification. The ministry has not.
Where is the 19 rules?
My lord.
19 rules.
The 19 rules, my lord, is not annexed. My lord, I have a copy. The 19 rules is of a different ministry altogether.
Health and family welfare.
Health and family welfare. Therefore, that query was made, my lord, whether this 19 rules is also applicable to the MHA or not. His junior senior clause is taken away, my lord, in the 19 rules.
Yeah, what is your take, madam, on this?
Yes, Justice.
See, the first issue has almost become redundant. After he has acquired this particular training of MOVC and he's promoted, now he says that there is also a clause at page 67, 66 that if juniors are promoted and if he finishes half of the time or at least 2 years, whichever is earlier, then also consider him. What will be the next promotional post?
2IC, man.
How do you call it?
The second in command. They write it as 2IC. I is capital, C capital, second in command.
From deputy commandant, you become a second in command.
Second in.
Your juniors have become second in command.
My lord.
Where do you make your submission that this 19 rules of Health and Family Welfare Department have been applied in Assam Rifles also?
My lord, it comes from the affidavit of the respondent.
Where?
Paragraph 11 for this year.
11
Paragraph 11.
of your affidavit. I have it removed. Latest RR. This latest recruitment rule is of Ministry of Health and Family Welfare.
In latest rule of, I think.
No, you have used the expression latest RR of 2019 at page 48 from the bottom third line.
Yes.
Latest RR recruitment rules have to be of the organization. Are these rules are also made applicable to you? It has to be done by a notification.
Yes, that,
In fact, that was the query made to the MHA. It is still silent on that aspect. Unless this instruction is obtained,
You
my
get
lord,
this
is black and white,
instruction.
my
You
lord.
get this is
My lord.
at least one part it is still open.
My lord.
So far as prescription of rules is concerned, we may not go with Mr. Pathak, but so far as the other,
Yes.
if he fails on the first one, he has to succeed on the other one because same rules. Heard the Pathak, the Pathak Learned Council for the petitioner. Para. Also heard Miss S. Burwa, Learned CGC. Full stop. The Learned CGC is directed to obtain instructions as to whether the notification of 2019 pertaining to the Ministry of Health and Family Welfare, Government of India, is made applicable to the recruitment procedures of the Assam Rifles, which is done as per the notification dated 2/8/2010. Correct?
Wait,
When can you get the instruction? List
15
after 2 weeks?
2 weeks.
List after 2 weeks. Yes.
Item 7.
Tip here.
My pleasure, Lordship. That is the case for the promotion. The petitioner falls under the category of P12B. And my lord, they have filed affidavit, my lord.
Okay. Item number
7, Lordship.
affidavit filed.
Yes, they have filed affidavit, my lord. That's why today is the fix for
Yes.
report.
We'll
Two of
take it up to Mr. Chaudhary. Which matter? Yes. We'll have it in the second half. 7, I think will take some time. 7, you are ready? Mr.
Yes.
Bu- Okay. 8 and 11. Okay.
Second.
Okay. Second half of the call. Affidavit is on record.
Yes, sir.
Your file reply also.
Reply also.
Okay.
That is also.
Okay, we'll take it up.
Lordship,
You joined as what? You have joined as what? In what capacity?
initially I have joined in the post of ADO, Agricultural Development Officer. Now this post, now I am claiming for the promotion for the post of SDAO, Subdivisional Agricultural Officer.
Subdivisional.
Agricultural Officer. This is the higher cadre.
Seventeenth 2016 you were appointed.
Yes, Lordship.
Your appointment was under that quota.
Under the quota, my lord. Physical handicap, my lord.
Okay.
Advertisement was made that the three post was reserved for the physically handicapped, and I was selected on that particular category.
Okay. Okay.
And what happened, my lord? This post is totally identified, purely identified. ADO post is identified for OS category candidate. And only OS candidate can apply for the post of ADO, my lord. The other category, the person are not eligible to appear in the examination to hold the post of ADO, my lord.
Okay.
And that has been identified. That list has, I have annexed the relevant portion, annex the
Page?
5 series, my lord.
Page.
Annex the 5, the relevant portion lost, you will find at page 33, serial number 65,
extension officer agriculture.
Yes.
Well, now in the year of 2003, my lord, this post has been redesignated as agricultural development officer, my lord.
Earlier it was extension officer.
Earlier it was extension officer. Now by the notification 2023, my lord, this post has been redesignated as the agricultural development officer, my lord. That notification I have annexed in my reply, my lord. And as per garrison list, my lord, I am in the zone of consideration, my lord. My serial number lost you will find at page 37, my lord.
37.
37 lost it. Serial number 106. That is me, my name. Nakibu Zaman.
One zero six.
106, my lord. 105 is also the fall under the same category, but he has not applied for promotion, my lord. He did not submit the required certificate of his disablement, my lord.
Okay.
That's
Okay.
when, my lord, after that, my lord, prior to me, my lord, kindly turn to page 36, 74 serial number. Sasanko Goswami has already been selected and promoted, my lord. He is also in the same category. He's senior to me, my lord. He has already been given the promotion, my lord. My lord, in this regard, my lord, central government and
No, Sasanko Goswami belongs to OH.
OA.
Okay.
Only OS category, my lord. Initially, my lord, the appointment has been made in ADO, and ADO post is purely identified only for the OS
OH.
category.
Okay. Oh.
No other person, there is no any scope for entry in the premises by other person of disablement. In this regard, my lord, the central government and state government, both government has issued the office memoranda in respect of the Act, 2016 Act, my lord. Earlier, this was the reservation total percentage was 3. After the new Act, my lord, it was extended to 4%, my lord. And category, there was a 5 category, my lord. That 2 categories considered togetherly. Below 2 categories are considered togetherly, my lord. That's why there is a 4%, my lord, to all the categories. My lord, state government, our government has issued a memorandum, my lord. Lordship will find that memorandum at page 52, Annexer 8. That memorandum dated 21st May 2022, Lord.
52.
Yes, 52, Lordship.
Yes.
Here, first, Lordship, kindly see serial number 2.2.
Yes.
2.2 against the post identified for each disabilities, of which 1% each shall be reserved for persons with benchmark disabilities under the clause A, B, C, and 1% under the clause D and E. These are the category, my lord.
Yes.
Blindness and low vision, deaf and hard hearing, locomotor, that is me, my lord, astigmatism and intellectual disability, and multiple disabilities, my lord. These are the posts, my lord. Now, my lord, kindly turn to page 53, my lord, in the bottom 8.
Page.
Next page, my lord, 53. Serial number 8 in the bottom, my lord. Interstate exchange and carry forward of reservation in case of direct recruitment and promotion, my lord.
Yes.
Here, 8.1 says, where in any recruitment year, any post cannot be filled up due to non-availability of a suitable person with benchmark disability or for any other sufficient reason, such post along with category of reservation shall be carried forward in the succeeding recruitment year. And if in the succeeding recruitment year also suitable person with benchmark disability is not available, it may first be filled up by interchange among the following 4 categories of disabilities at 1% each to each category. My lord, that means, my lord, that disabled person, the reserved post for disabled PWD, that cannot be filled up by the another person. That post may be kept vacant and carried forward to the next succeeding year as the backlog vacancy. That is cleared by point next page, my lord, 54, 8.2, 8.3, and 8.4, my lord.
Yes.
8.2 says, lordship, if the nature of post in an
establishment is such that a given category of persons cannot be employed, the post may be interchanged among the above mentioned 4 categories with the prior approval of the Social Welfare Department.
Yes.
And next, my lord, 8.3 says, if any vacancy to a post reserved for any category of benchmark disability cannot be filled up due to non-availability of suitable persons with that benchmark disability or for any other sufficient reason, such vacancy shall be carried forward as a backlog reserve vacancy to the subsequent recruitment year or promotion. Number 8.4, in the subsequent recruitment year, the backlog reserve vacancy shall be treated as reserved for the category of disability for which it was kept reserved for in the initial year of recruitment. However, if a suitable person with the benchmark disability is not available, it may be filled up by interchange among the categories of benchmark disabilities identified for reservation. Now, my lord, what happened? The DPC was held. DPC was held, my lord, on 22/6/2023, my lord. The total strength of the SDO cadre is 165, my lord. Total strength of the cadre SDAO, my lord, is 165, my lord.
Yes.
And lordship 0.5A in the middle part of the annexure 9, page 58.
Yes.
A, B, C, D, E, F. Let us strength and clarify how many posts is occupying and how many posts is vacant. Cumulative vacancy as on 30/11/2023 in SDO cadre is 170. And my lord, DPC has recommended, my lord, 119, my lord, where my lord Sasanka Goswami has been recommended, my lord. Lordship will find his name at page 62, serial number 115.
Page 11.
No, page 62. That's Sasanka Goswami. He's senior than me, my lord. Only he has been recommended by the DPC, my lord. His name at serial number 115, my lord. Sasanka Goswami is general, physically handicapped.
Yes.
His rank is 32. Recommended for promotion. Accordingly, my lord, he got the promotion. In this meantime, my lord, I have submitted a representation and ventilating my grievance that I am also entitled, but I have not been, my representation had not been considered at that time, my lord. And the promotion has been made and 91% has been promoted, my lord. That promotion letter, lordship will find at page 65, annexure 11, dated 29 August 2023, my lord. And my lord, Sasanka Goswami has been appointed, promoted at serial number 88, my lord. Only he has been considered and he has been promoted, my lord. Physically handicapped, in the category of physically handicapped, out of 4%.
How many have been promoted? 91.
In the category of PWD, my lord, out of 190, my lord, 4%.
Now total, this is the promotion list of how many persons?
Only 1%, 91% has been promoted, my lord.
All SDU.
All are SDO. SDO is the cadre, my lord. There are various posts, my lord. There are altogether, my lord, 23 posts in the same rank of SDAO. Here, my lord, all posts.
Okay, then what happened?
What happened, my lord? In this regard, my lord, I have submitted a representation. I said that, my lord, I pray before the authority that I am also entitled to get the promotion. Why, my lord? Kindly turn to page annexure 7, my lord. There's a central government
Page
38, my lord. Annexure 7, lordship. This is the memorandum issued by the central government. Central government make it very much clear that page 41, my lord, relevant page, 0.6.1. This was issued on 17 May 2022 by the Personnel and Public Grievance and
yes,
Pension
page
it is started from 38,
That we know.
and
Which
a
page?
relevant portion logic will find at page 41.
41.
41.6.1 in the middle.
Okay.
I'm reading, my lord.
Yes.
If in a ministry, department, organization, a post is identified suitably only for one category of disability, reservation in promotion in that post shall be given to the persons with that category of benchmark disability only. However, reservation of 4% for PWD shall not be reduced in such cases, and total reservation in the cadre will be given to PWDs for which it has been identified. Likewise, in case of post is identified suitable for two categories of disabilities, reservation shall be distributed between persons with those categories of disabilities equally, as far as possible. It shall, it shall, however, be ensured that the reservation in different posts in the establishment is distributed in such a way that the PWDs, as far as possible, get equal fair representation. The point used in the 100-point roster after a gap of 25 points shall be used to give reservation. In other words, it will be given only at the point reserved for PWDs and not in the branch manner. Now, my lord, in this case, my lord, initially, my lord, the post is direct recruited ADO, my lord. ADO is identified as the only for locomotor, my lord, that is OS, my lord. The other category person, the presence of the other category person does not arise because they cannot enter in the premises, my lord, because this post is identified for the locomotor and advertised for the post of only specially for the locomotor PWD, my lord. Therefore, my lord, and while the promotion has been made to the next cadre, higher cadre, this cadre can be higher cadre SDO can be filled up among the person who are holding the post of ADO and senior ADO. Senior ADO is a post, my lord. The persons who are holding the post of 5 and more year as a ADO, they are transferred to the post of senior ADO. That means, my lord, from two category of persons are eligible to get promotion in the next higher cadre of ADO, my lord. As per the service rule of their, as per the Assam
Now, what is
Agricultural
your
Service-
case? What is your case? Tell us. You
My
are
case is that, madam, at the time of the recommendation made for the second higher, next higher post of SDO, I have not been considered since out of 119, my lord, 4 persons should be considered.
Hmm.
Only 1 person has been given the benefit of that particular provision. But here they have filed an affidavit, my lord. In the affidavit, they have said, my lord,
That is 4% of 119 vacancies. That is four vacancy persons with disabilities. But if it comes to 21st May, the notification. So the persons with disabilities is divided into blindness and low vision A, deaf and hard of hearing B. Page 50, page 52, Lord.
my lord, that is 2.2, my lord. 2.2, if it is open for the fourth
But the
category, my
persons
lord,
with-
that is 1% for each.
okay. Let Mr. Bora finish. Then we'll come to you.
And, my lord, in this affidavit, my lord, they have said, they have annexed an annexer, my lord. What was the affidavit, no? Here, paragraph is 6, my lord. In the affidavit filed by the respondent, my lord, at page 7, serial number 71, my lord.
Yes. What has been
Yes,
said?
in the 6, my lord, they have stated that the answering deponent back to page 71, my lord, serial number 71, my lord.
Yes. Say paragraph.
Paragraph 6 in the bottom, my lord.
Okay.
That's it.
Yes. Yes.
That as regard to the statement made in paragraph 7 and 9 of the writ petition, the answering respondent begs to state that the review meeting of the selection board was held on 30/9/2023 for reviewing of the minutes of the selection board meeting held on so-and-so, continued on so-and-so. In the review meeting, application submitted by the petitioner of the incident case was placed before the selection board. The committee discussed about the petition of the Mohammed Nekibur Zaman, ADO, Katigora, Circle, Kasar, Office of the District Agriculture Officer, Kasar. The decision of the selection board was taken by point number B of minutes of the meeting held on 30/9/2023. The decision is reproduced herein under. This is the decision, my lord, that has been supported by their annexer, my lord. That annexer has been annexed at page 74, my lord. Page 74. Turn to page 75, my lord, B.
Read the minutes, it has been,
The minor, in the minor, it is said the committee also discussed about the petition regarding the promotion to the post of SDAO of physically handicapped quota submitted by Mohammad Nekibur Zaman, ADO, Katigora Circle, Kasar, Office of the DAO, Kasar, Silso, which is placed before the selection board. The selection board decided that the petition of the Nekibur Zaman cannot be recommended for promotion to the cadre of SDAO as reservation for benchmark disability is 4% against the total cadre strength. As per the medical certificate, the applicant belongs to the category of locomotor disability, which deserve only 1 out of 4%. The roster point of locomotor disability are already filled up by Siri Sasanko Goswami against the RP number 32 UR and Rokibul Faruqi, RP number 147 UR as per OM so dated 21/5/2022. He is the earlier category, my lord. Now he has not in the same post, he get the promotion to the next higher post, my lord, assistant director. He is the Rakibul Faruqi. He has already got the promotion. And in this regard, my lord, I have said that, my lord, this what they have taken the stand in the meeting, my lord, this is total violation of their own office memorandum. 1%, no doubt, my lord, 1% for the locomotor, but what about the another 3%, my lord? As per the office memorandum point 8, it is clearly stated that, my lord, if there is unavailability of the disabled person, my lord, that post cannot be filled up by the another category of person. That means reserved, unreserved, any person. And, my lord, if the other category persons are not available in the department, then, my lord, that should be interchange between the 4 category as per the availability of the person. And here, my lord, what happened, my lord? Initial appointment has been made only into the category of locomotor, my lord. Therefore, my lord, the other category of PWD does not arise, my lord. There is no any scope to enter in this premises, my lord. Because in the advertisement, my lord, this is specially reserved only for the locomotor, my lord. And SDO post can be filled up amongst the persons who are holding the post of ADO and senior ADO. Senior ADO is the persons who are already completed the 5 years of service, continuous service, 5 years or more. They are transferred to the next higher post. Now, my lord, my petitioner has also transferred to the senior ADO, my lord. By senior ADO by order dated 1 March 2024, my lord. And my lord, therefore, rule, my lord, rule 12(5). That is the transferred, my lord.
okay.
Order dated 1 March 2024, my lord. Your lordship will find the name of the petitioner. He has already been transferred to the senior agriculture development officer, senior ADO.
Serial number?
That is, I have given the serial number. His serial number is 85, lordship. Page number 6, second bottom. And their rule says, my lord, this is the rule, my lord, their service rule.
What is the name?
This is the
Name-
rule, Assam Agricultural Service Rule 1980. নতুনখনে পুৰণা পুৰণাখনত
এখন নাই। Is it available here in this book? No.
that is not available, but the new edition it is available.
What do you want to show in this rules?
In rule 12, my lord. Rule 12. 12(4), Roman 5. Rule 12.4 says,
12.
Rule 12.4 says, my lord, subject to the suitability as may be decided by the board and by the appointing authority as set forth in Rule 13, and also subject to the possessing qualification and experience as prescribed hereinafter, an officer shall be eligible for promotion from one cadre to another of the service in the manner provided below. My interest in 5, my lord. Next page, 5, my lord. From agricultural extension officer.
Yes.
That is my lord, now ADO, my lord.
Yes.
And as junior subject matter specialist, that is also known as the senior ADO, my lord. That is that notification I have annexed in my reply, my lord.
That is okay. Then what here?
Now, my lord, since this ADO SDO post can be filled up to that particular two category of person, my lord, and at this stage, my lord, 3% and the 4% goes to the locomotor, my lord. That should be stated in the point 8.3 and 8.2 clearly stated that the interchange may be made with the prior approval of the social welfare department. They knows, my lord, there is a total vacuum of the another category of PWD candidate. Only locomotor candidates are holding the post of ADO. From ADO and senior ADO, my lord, promotion has been made to the next higher cadre of the SDO. They did not do so. Only they have made the one person, Sasanka Goswami, to the next cadre of SDO. But what happened? Another 3%. That post cannot be filled up by another person, but they have filled up all person by another category of person. Another category means the general, OBC, ST, not by the PWD. For physically handicapped person, my lord, only one, Sasanka Goswami. Instead of one out of 130, 119, my lord, it may be 4, my lord. If there is no person, my lord, only locomotor is there. As their affidavit says, 1% for each category, then another 3 category must be kept vacant, my lord. Should be carried forward for the next succeeding year, my lord, for promotion. That should not be done. What they have done, my lord, this is total violation of their own office memorandum and also the provisions of section 34 of this act. Right of Persons with Disabilities Act 2016, my lord.
Section?
Section 34, my lord. Lordship will find at page 21.
Yes. Of the act.
Of the act, lord.
Yes, please.
Chapter 4, my lord. And turn to next page, my lord.
Section what, 30?
34, my lord, in the bottom. Yeah. 16 from this.
You can know.
16 from 14 this and 94 this. 96. 96 this.
Not okay. Huh? No, 1996 it ruled 25. You're reading which section?
Section 34. Okay.
You can't क्यों बस सफाई से repeal लिखी? $34, you have said?
Yes, reservation.
Yes.
That is 34.1. 34.2, my lord. Lord.
Yes.
I'm reading, my lord. Where in any recruitment year, any vacancy cannot be filled up due to non-availability of the suitable person with benchmark disability or for any other sufficient reason, such vacancies shall be carried forward in the succeeding recruitment year. And if in the succeeding recruitment year, also suitable persons with a benchmark disability is not available, it may first be filled by interchange among the 5 categories, and only when there is no persons with a disability available for the post in the year, the employer shall fill up the vacancy by appointment of persons other than the persons with disability. Provided that if the nature of vacancy is an establishment is such that a given category of persons cannot be employed, the vacancy may be interchanged among the 5 categories with the prior approval of the appropriate board. That is the point 8, like point 8 of the memorandum issued by the deputy government. My lord, by recommending the 190%, my lord, the DPC boards violated the provisions of the statute as far as, my lord, the office memorandum. They knows everything, my lord, that initially appointment, my lord, made only for the locomotor. One person has been promoted from the category of locomotor. But what about the another category, 3%, remaining 3%? That is filled up by the another person, my lord. That is the violation, my lord. Either may be interchange and I may be promoted or keep vacant for a next succeeding promotion. That has not been done. This is my solution.
Yes.
And my lord, one clarification, my lord, the Faruqi, whose name has been recommended in the committee, my lord, he got the promotion on 30 January 2024 to the next higher post of assistant director of technical sector. It is here, my lord. This is the promotion.
Who is this Faruqi?
Faruqi, his name has been reflected in the minutes of their affidavit, my lord, in the next. He at the time of the recommendation, my lord, promotion, my lord, he was as the SDO, the physical handicap, my lord. Only one person at that time, my lord, only one person was promoted. And now Prashanto Goswami is promoted. They said, my lord, out of 165.
No, Faruqi was already in the higher
Done.
post. He was in the higher post.
Already done, my lord. Now, my lord, only 0.5% is holding the post. Only 0.5% has been considered to the SDO at this present status. Out of 165, my lord, 4% is the 6.
Yes, madam.
I think that chief lordship, I have to take the instruction. But my lordship, as per my affidavit, this prayer was for a review deputy. We have done the review deputy and we have given a decision, lordship. And regarding persons with disabilities, lordship, it has been divided into 4 parts.
Where is the review DPC?
Review DPC is lordship
I have it.
at page 74 of my affidavit in point B, page 75. The selection board decided that the petition of Nikibu Jaman, that is the petitioner lordship, cannot be recommended for promotion to the cadre of SDAO as reservation for benchmark disabilities 4%. Against the total cadre's rank. As for medical certificate, the applicant belongs to the category of locomotor disability, which deserves only 1% out of the 4%. The roster point for locomotor disability are already filled up by Shri Sasanko Goswami against roster point number 32 and Rakibul Faruqi number 147 as per OM dated 21st 5 2022 issued by the Personal B Department Government of 117 posts, 4% is 4 posts. Vacancy was 117. 4%. And the 4 posts were divided into lordship if comes to the OM dated 21st May 2022 lordship annexure 8 page 52 of the writ petition. 2.2 lordship.
No, in this review DPC,
Yes.
which part are you emphasizing?
The B, lordship page 75 point B. Page 75 point B.
Yes, please read again.
The committee also discussed about the petition regarding promotion to the post of SDO on physically handicapped quota submitted
He's
by
the petitioner.
that is the
Nakibul.
petitioner.
Okay.
Yes, the selection board decided that the petition of Nikibur Zaman cannot be recommended for promotion to the cadre of SDO as reservation for benchmark disabilities 4% against the total cadre rank. As per medical certificate, the applicant belongs to the category of locomotor disability, which deserves only 1% out of the 4%. The roster point for locomotor disability are already filled up by Shri Sanka Goswami against roster point number 32 and Rakibul Farooq, roster point number 147 as per the OM dated 21st/5/2022 issued by the Personal B Department, Government of Assam. So, Lordship, for locomotor disability, there was only 1% of the total post.
It's 52. But what Mr. Barua is
That is what
saying that
the other three
the other vacancies meant for this category
Yeah.
were not filled up.
persons with disability total category.
No, were not filled up. So if that is the case, first you have to carry it forward for the first year.
Yes.
And if it still exists, the same situation exists, then with the approval of the State Welfare Department, you can interchange the aspect, the segment of the disability. He belongs to the OH category. But he says that
For
vacancies.
the OH category, there is only one post, Lordship. In that post, Shashanko Goswami, who is far above him, the petitioner in the gradation list, he has been appointed. So next remains the other 3% of the vacancy. So whether persons with disabilities were appointed in that list, Lordship, that instruction
No, that is the case he's trying to build up.
if
That
it
there
has
are
to be interchanged.
vacancies in the major category, broader category of PWD.
Yes.
And only one post has been filled up under this category. Rest three are still open. And he can be considered because there are no other persons.
We were considering him for only locomotor disability because if Lordship comes to Annexure 8, page 52 of the writ petition, may I read, Lordship?
52.
Page 52.
Yes, please.
Against the post identified for each disability, of which 1% each.
2.2.
2.2, Lord.
Yes.
Against the post identified for each disabilities, of which 1% each shall be reserved for persons with benchmark disabilities under clauses A, B, and C, and 1% under clauses D and E, unless otherwise excluded under provisions of para 3 hereinafter. So for blindness and low vision, 1%, deaf and hard of hearing, 1%, locomotor disability, including cerebral palsy, leprosy, cure, dwarfism, acid attack victims, and muscular dystrophy, 1%. And for D and E, autism, intellectual disabilities, specific 1%. So, Lordship, if we were considering his case was for locomotor disability, 1%.
1%. He is not on he is on clause 8 at page 53.
Yes, yes, sir.
And which has taken
Interchange.
the form of the statute. After this, as per the OM, the statute also has this provision. You come to page 53, clause 8.
Yes, sir.
Have you done the exercise of clause 8?
That instruction, Lordship, I have to take.
And first,
Regarding the other three vacancies.
and first
whether-
to do the exercise, you need to ascertain whether other three vacancies which are meant for this category are filled up by persons of this category. He says there are no other persons.
And whether it has been,
If it is not filled up, then you have to do an exercise under clause 8.
yes, yes. That instruction, Lordship, I have.
Petitioner being the eligible candidate
Yes.
after Sasanka Goswami, he has to be considered.
So if clause 8 has.
Now, clause 8, you have to apply your mind under clause 8. But what is your affidavit then?
Affidavit was for the locomotor disability, Lordship.
That 1% is very clear. 2.2, only 1%, no
Yes,
problem.
2.1%.
But if vacancies still exist, if there are no persons, but persons in a different category is there,
Not filled up, then it has to be
interchange, not in the first year. First year, you just carry it forward. On the second day, see the expressions used at clause 8.
8.3.
Clause 8 into 8.5, I think.
8.3.
8.2, 8.3, 8.4.
This is for backlog, 8.3 for backlog tickets. Interchange,
No, 8.1, read 8.1. Read 8.1.
wherein any recruitment year, any.
Where, not
That is 53,
wherein.
my lord. That is the page 53 in purport.
53, yes, not wherein, it's
My
where.
lord, inter excess and
Where
Where
in,
in any recruitment year, any
don't say
post,
wherein.
where in any
Yeah.
recruitment year, any post cannot be
There's a
filled up.
comma after where.
Yes. In any recruitment year, any post cannot be filled up due to non-availability of a suitable person with benchmark disability or for any other sufficient reason. Such post along with
The category, along with category of reservation.
such post along with category of reservation shall be carried forward in the succeeding recruitment year. And if in the succeeding recruitment year also suitable person with benchmark disability is not available, it may first be filled up by interchange among the following 4 categories of disabilities at 1% each of each category.
First year, you do not do anything. If persons are not there, you have to carry it forward. You cannot give it to any other person. Second year, again, if the same situation exists, then you can interchange. A person with a different benchmark, he also can be considered. Now, you may be right in contending that so far as which benchmark is concerned, there is only 1%. And Sasanko Goswami has already been given the appointment, a promotion. But the petitioner says that there are still more posts to be, which would fall under this category, under this quota, and there are no other persons. So in that category,
instruction, may kindly give me some time to get it.
that is the only instruction. First line of argument which was made on the last occasion, we are not agreeing with it. That 1% benchmark is meant for 1%. But if there's a clause for interchanging, then you have to apply your mind. When can you get the instructions?
Next.
next Tuesday.
Next Tuesday. Okay. Heard 3. D. Barua, learned counsel for the petitioner. In the course of his argument, 3. Barua has referred to section 34(2)
Yes.
of the Rights of Persons with Disability Act 2016, along with clause 8 of the office memorandum dated 21/5/2022. Full stop. As per the aforesaid provision, an exercise is required to be done in case of non-availability of a candidate with the benchmark disability. Full stop. Para. Ms. R. Bora, the Standing Counsel of the Department, Agriculture Department, submits that she may be given some time to obtain specific instructions in this regard. Full stop. Para. As prayed for. List on. Is it second? The 3rd? 3rd of September. To enable the Learned Standing Council to obtain the instructions. Okay.
I keep the rule for the
Apply.
You can provide it.
Okay.
Yes.
I have to a petitioner claiming the pensions, GIS and gratuity and other amounts left by the deceased, though the succession certificate is already issued against the debt and securities, but pensions and JS and gratuity will not release on my, because we are the parents, the petitioners are parents of the deceased, oldest parents, second wife with minor children. And first wife is the respondent number 678, first wife and 2 daughters. On the last occasion, they were already admitted to release the amount in our favor. As per order, we are already submitted the bank account to him also. On last the 2/8/2024 order.
2/8.
2/8.
Yes, what is the development?
Lordship, I'm for the private respondents,
Number 6.
6, 7, and 8. Six
Okay.
is the wife and 7 and 8 are the daughters. So your Lordship, on the last occasion, on the first day after the service of the notice, we brought it to the notice of this honorable court that the gratuity payment order and the family pension payment order has been granted to us. We got it in March 2024. And therein, it was reflected that and the provisional gratuity, the entire amount of provisional gratuity has been credited to my account. So this honorable court was asked me whether my client, whether she is ready to apportion an amount. I took the instructions and I also filed an affidavit, your Lordship. Actually, what has happened, your Lordship, the entire pensionary benefits, all the pension, maybe all the pensionary benefits, I don't know whether it is a share or entire thing. It has been deposited in the account of the respondent number 6. I don't know whether it is the entire amount or a part of the amount.
Okay.
And that amount is around 11,92,000 something. Now, Lordship, as per my instruction, there is some LIC amount which has been credited to them. So now the only possibility that I see, there are 2 possibilities, either a civil suit or an amicable settlement outside the court. So I prefer the second option. And I had a talk with my clients to explain to them what are the consequences if the entire amount of pensionary benefit has been credited to the respondent, then she is liable to give it back. Then the thing is that if a pensionary benefit should be paid to the petitioner, then the LIC amount should be parted with. So ultimately it's the same thing because LIC amount is around 12 lakhs. So amicable settlement is the best way possible for the pensionary benefits, what I see, instead of going for a civil suit again. So this is my humble submission, Lord, regarding the pensionary benefits that has been credited to my account. I don't know because there was no misrepresentation, no fraud on my part. It is not the case. And I don't know whether the entire pensionary benefits has been credited to my account. That clarification will be required. So that is regarding
Which department?
Police.
Huh?
Home Department.
Home
Police.
Department.
and regarding the pension, your Lordship, regarding the pension, it is already settled that the pension will be paid to the wife. She will get it. Till now, she has not received the monthly pension. So once the pension is credited to her account, then she will definitely maintain the family. It is not the case that she will not maintain because till now she has not received the family pension yet. FPPO has been issued, but till now it has not been credited. So now Prima is just holding a view that she will not maintain. That will be wrong, your Lordship. And your Lordship, what I submit at this stage, the best option will be disposing the case in the light of the judgment passed by the full bench judgment of this honorable court in Junufa Khatun. That will be that's what I suggest, your Lordship. Please, I may kindly refer this judgment, your Lordship, the full bench judgment. If your Lordship is kindly pleased to have a look at it.
That is on personal law. This is a party.
Yes, ma'am.
The parties are Muslim in that case.
Exhibit.
Where
Lordship,
second marriage is permissible.
yes, your Lordship, but there is a general view that has been held. If your Lordship may kindly take paragraph number 22.
Yes, we have read 22.
Yes, your Lordship. So it's a general, it's not only for the Muslims. It's a general that whenever a wife gets it, she gets it as a trustee. And she is liable to maintain the family. And if she doesn't,
Family including the second wife of a Hindu, Hindu. Then
others who are entitled to benefit, including the second of what, your Lordship, if your Lordship kindly take paragraph number 22, it will say for all such other persons who are entitled to the benefit.
It's not like that. The legitimacy of the children are not in doubt in a Hindu family under the Hindu law.
My Lord.
This is not this will not be applicable to in all cases. They are governed by the Mohammedan law.
This is
See,
not acceptable in
that is the premise under which this case was decided.
But Lordship, the pension, till now I have not received the pension. So apportioning it at
Can you
this
sit and decide, sit and talk?
They claiming about the LIC amount. The LIC
no.
amount, we are not about the LIC amount whatsoever. But he was in.
We are
yes,
not on the LIC or pension.
we just.
Why don't you sit and decide?
Yes, definitely.
We have a mediator in this court itself. Yeah, the parties belong to which place?
I'm from
Jorhat.
Silchar and they are from Jorhat.
We are the parents and 85 and 80 years.
And who are the others? Who are the others?
Second wife and the minor children.
Second wife would be the correct word, Your Lordship.
You are the second wife.
We are the second wife.
Sangeeta Bora Sekhya.
Sangeeta
You will
Bora
not have any status.
Yes, I know, my lord. But my
But
parents,
your-
my father-in-law and my parents-in-law.
And but your the children will have a.
Yes, my lord.
Yes, definitely. Mother-in-law,
Three
father-in-law.
are minor children.
Minor children.
Mr. I think that will be the best. Not local adalat, mediation. First, you try to mediate and chalk out a solution. No point disputing and wasting time of the parties. You come to advise your clients, both of you,
Yes, yes, Your Lordship.
and come to a amicable settlement and settle the matter. Considering the dispute involved and as agreed to by the learned counsel for the contesting parties, the matter is referred for mediation. Full stop. কোন আছিল? আছে না? গোটেইখিনি থকা আছে না? এইখিনি তো লাষ্টৰ খিনি, আগৰ বিলাক ছিল। আচ্ছা আচ্ছা, অল পেনেল আছে না? আচ্ছা, অল পেনেল। Suggest anybody? Bijan Chakraborty. Not Biplab Chakraborty. This court accordingly appoints Sri Bijan Chakraborty, mediator, to act as the mediator in this case. Full stop. The parties assisted by their learned counsel are to furnish a copy of their respective documents to the learned mediator within a week, within 3 days from today. And the learned mediator, 3 days from, along with a copy of this order. 3 days, within a week from today, along with a copy of this order. The learned mediator will thereafter fix an appropriate date and time by taking into consideration that the parties are not residents of Guwahati. Full stop. Let the matter be listed on 27th, 1, 2, 3, on 20th of September for submission of a preliminary report by the mediator. Full stop. Such report may be furnished through the registry of this court.
Obliged, Your Lordship.
Kindly inform Mr. Bijan Chakraborty. You take this back.
May I please, Your Lordship? This case relating to promotion from grade 4 to grade 3, Your Lordship, is the second round of litigation. And
Yes,
Earlier
instructions,
Instruction not yet received, your lord.
get the instructions,
Yes, your lord.
notice was
We'll file
issued
an
here.
affidavit, lord.
Okay. This is which department?
PHE.
Sri R. Google and Standing Council, PHE department. Prays for and is granted 4 weeks time to obtain the instructions / file affidavit in opposition.
Short date may be given, we are going to retire.
So come-
Second out the
Come up for the first time after notice.
Yes, sir.
4 weeks.
Weeks may.
File it.
Lordship. Praying for fixing a date, Lordship. There is an interim that may be continued, Lordship.
What kind of interim order?
They are not to fill up 3 posts.
List on 20th of September 20.
Sure.
Interim
Obliged.
order passed earlier to
Obliged.
continue till the next date of listing.
Obliged.
Yes.
Item 10.
Lordship, kindly pass over the matter for time being.
Mr. Chaudhary,
Yes, Lordship, is there.
IA for?
I have for increasing.
Is for increment.
Okay, let him come. We'll have it.
Time
11 for 50.
11 of time.
11. No, proceed.
Lordship, in 11, Lordship, we have received instruction, Lord. And
Matter.
this has been reviewed, Lordship. Up to 10. Oh. I have received terabytes of the Lordship.
When was the order of suspension?
Prosecution sanction has also been
Suspension order.
earlier it was reviewed on June, Lordship.
Okay, second time reviewed.
Yes.
It has been reviewed, madam. Suspension is the only matter of challenge.
Yes, Lordship. 30/12/2023.
As far as my instruction, Lordship, it has been reviewed in June, Lordship, then done again on the August,
Lordship,
Lordship.
kindly pass over the matter for time being. My signature.
I'm being, okay, after some time.
Item 12. The last order you left. 19/8/24. So I think.
What was the initial order?
Initial order is at page 17.
Something has been done here.
No,
Are you
they
aware?
said,
Are you aware, Mr. Das?
they've given this paper now, but if your lordship looks into page 17,
Of your petition?
yes, contempt petition,
17.
yes. For the reasons stated above, this court is of the considered opinion that the impugned order dated 2006 for the petitioner, thus cancelling his order of regularization, is on the face of it arbitrary and set aside the same is accordingly set aside. Respondents are directed to give all consequential benefit to the petitioner pursuant to his regularization of service with effect from 2005 after adjusting the pecuniary benefits, if any. This benefit, I don't see, Mala, they have calculated anything. Since 2005, this order was not regularized. So this consequential benefit has not been given in this thing. Some pension exercise has been done. The aforesaid exercise shall be carried out and completed expeditiously.
No, the DCRG is also done. DCRG
Yes,
Uh,
calculation of
average
pension and
emoluments.
DCRG. That's all, my lord. Regarding pay, my lord, that benefit. He's entitled
No,
because
average, statement of average emolument for last 10 months of basic pay, that is also there.
well, let them give the details, whatever they have given. It is still lying in the office of the accountant general.
Accountant and sign off.
Let them give the details, I will come back next.
Yes. In the meantime, you can take instructions.
Yes.
also. Uh,
But they should give me the details.
Three, R. Gogoi, Learned Counsel,
Okay.
appearing for the response numbers 1, 2, 3, and 8, has placed before this court a communication dated 22/7/2024 issued by the Executive Engineer PH, Umrangso Division to the Accountant General, Assam, in respect of the pension papers of the petitioner. Full stop. A copy of the said document, said communication is also handed over
Just
to 3,000 Learned Counsel accompanying the Senior Counsel Sri B.D. Das. Para. Let instructions be obtained, let further instructions be obtained by the Learned Counsel for the parties. Full stop. Sri Gogoi would also obtain the details of also obtain further details of the entitlements given to the petitioner pursuant to the order dated 19/7/2023, passed in the connected writ petition.
This enclosures,
I'll
my lord,
Thank
they
you.
should give.
List on. We'll have it on 18th. 18th.
Obliged, Lord. That may be part of, may make a part. May I-
That matter relating to promotion, my lord. Earlier, I was a grade 4 employee, my lord. Thereafter, my promotion was made, my lord. And by the impugned order, my promotion again reverted back to my earlier post, my lord. In this connection, lordship may kindly peruse the first order dated 12/5/17
Of this court?
of this court.
Yes. Okay. Now, what is your take, madam? Have you filed your affidavit?
They have filed affidavit and we have made reply to that.
Okay.
Yes, Lordship, in other matters, it's a covered matter, Lordship. Some other petitions have been disposed.
My lord, earlier by this court, some orders have been passed, other similar matters, my lord. And
Is it
my
covered? Covered?
covered, my lord. My payer is for promotion and the other benefits, my lord.
Where are the orders?
And from the impugned checklist, one Abdul Kaif Ali also approached before this honorable court, my lord. That what I have furnished.
You showed to madam. You, if it's covered, consensus of the parties will dispose in the same lines.
Okay.
You have a copy of this, madam? Abdul Kaif
Abdul
Ali?
Kaif.
You have a look at this and make the corrections, hand it over to our court master. We'll dispose them in the same lines. Mr. Bora?
And two others also.
No, give one, whichever is feasible. Make the corrections, hand it over to the court. Take this one.
Nirada.
But first, there has to be a consensus that is covered. Both the parties have to. Correction could be.
Yeah, that is.
Make correction by pencil, both of you, and give it to our court master. Dispose this off.
Right.
Dispose. Make the corrections by pencil. Look.
May I please, Lordship, kindly pass upon the time being, Lordship. People for a look into matter.
What is the matter, Mr. Chaudhary?
2018, Lord.
What is the matter?
Matter, my lord, I am actually, my lord, it is a parity of penalty. Out of the 8%.
Parity of?
Penalty. Out of the 8%, my lord, only I am awarded the punishment of removal from service.
Others?
Others were stoppage of two increment. Someone was given compulsory retirement.
The charge against you must be serious than others.
Charge, yes, charge otherwise serious, my. But cause of action is same. Out of the same
No, your role may be more.
That's why, my lord, record was called for in the last occasion.
Okay, let Mr. Bora come.
Lord, sir.
Yes.
The matter relates to removal of the petitioner from service just one day ahead of his return.
Which department?
The handloom and textile.
277019. Yes, Mr. Dhar, ready with the record?
I have received the record, my lord.
Okay. Mr. Sharma, you can start.
Three show cause notices have been issued. My lord, I am going to one by one. My lord, you may take into note the first show cause
You're
notice.
working as what? Serving as what?
Assistant director at Gwalpara. And therefrom I was removed from service on 30/10/2015. 31st of October 15 was my retirement.
You're removed.
I was
Yes, tell us.
page 38.
38.
38 is the first show cause notice.
Two 2003.
2003. It was the first show cause notice.
Yes. Yes.
Here, two charges were framed against me. Charge number one, while you were serving at ADHD, you had submitted a proposal directly to the government of India for sanction of a fund under work term housing scheme for 16 PWCS. File your numbers to ensure dated Q6/2003 without obtaining the approval of appropriate authority. That is Director, Handloom and Textile, and also the government of Assam. And based on your proposal, government of India has accorded sanction of rupees 20. This amounts to an act of insubordination. You are therefore charged with willful violation of laid-down proposal. Charge number two, that while forwarding the state proposal to government of India, you have submitted a minute of meeting of state level project committee, which was 6 years wherein you have forced the signature of the director, secretary, finance, and others. Moreover, the constitution of state level project committee was a manipulated one, as the members from thereof were not actually the members of state level project committee. You are therefore charged with the act of forgery and sitting with the malafide.
Okay.
Against these two charges, I have submitted my reply denying the charges as leveling. My
Yes.
reply was at page 40.
Page
Page 44
44.
is my reply.
Just a minute.
What happened to that so-called notice? But no disciplinary proceeding was drawn up against me subsequent.
No repeat drawn up. Thereafter, what happened?
What happened, madam? After submission of my reply, what happened to that, madam? Regarding to that so-called notice, I was not aware of. I was not any notice was given to me. So for the subsequent step that has been taken by the respondent. Thereafter, my lord, second so-called notice has been issued to me on different side. That was at page 45.
45.
45.
Yes.
As many as 4 numbers of charges have been leveled against. The first one relates to, my lord, I did not maintain cash book record, cash book or any record in relation to receipt and expenditure of the amount received from the government of India or the state government with amounting to rupees 3 crores something.
Yes.
Charge number 2 relates to, my lord, since I failed to maintain subsidiary cash books for which it was you have failed to maintain subsidiary cash books against each project showing the financial
Charge
position.
number 2.
Charge number 2. Page 55.
Same as 1 almost.
Almost same. But my lord, showing the financial position of individual project, resulting difficulties in monitoring the schemes. There's a negligence, gross negligence towards that.
Yes.
Charge number 3. The allegation was such that without taking approval and sanction from the competent authority, I issued supply of orders of looms and accessories to the tune of rupees 75 lakhs. Accordingly, gross misutilization of official power that has been leveled.
Yes.
Now, charge number 4, my lord. I opened a current bank account in the bank without the approval of the department, intimation of the department.
Yes.
That charge has been leveled against. Denying all this, my lord, I have submitted my reply, which is at page 54 and it's
54.
54.
Yes.
Now, my lord, so far this disciplinary proceeding related to second supposition. The disciplinary authority, the inquiry authority, my lord, has submitted the report, inquiry, but that was, my lord, rejected on the ground that the disciplinary proceeding was concluded without following the procedure. That part is at my lord, page 60, my lord, next 30. Second paragraph, my lord. On perusal of the inquiry report, along with the enclosures, it seemed that the inquiry officer did not follow the prescribed procedures in conducting the inquiry. The inquiry was conducted in a perfunctory manner without even recording the statement of the delinquent officer or examining any of the witnesses, leaving the inquiry incomplete. Therefore, in view of the above facts, the government of Assam is pleased not to accept the findings of the report and further pleased to order a dean of inquiry into all the charges brought against the delinquent officer. Accordingly, one
Okay.
Durgadhar Bonia was appointed.
By the way, what was the report, findings of the report?
That report was not furnished to me. After my lord receipt of that report, my lord, it was rejected, saying all this down. Hereafter, my lord, de novo inquiry was, my lord, continued. I was not
Review inquiry started.
start.
Yes, thereafter.
Hereafter, my lord, that my lord, so far the inquiry as regards to my lord second super's notice is concerned, my lord.
What is page 63?
Page 63, my lord. It is part super.
Another.
I will come to that. What happened in this regard, my lord? After completion of the de novo, my lord, inquiry, during the pendency of de novo inquiry, my lord, the earlier, my lord, inquiry officer was, my lord, retired. Accordingly, new, my lord, inquiry officer was, my lord, appointed, and he submitted the report, intimated that on account of the non unsatisfactory reply, the inquiry has been conducted, and he accepted the inquiry report, which was rejected earlier by the government. That is at my page, my lord.
Page?
Page, my lord. 97.
97.
Nine.
Yes.
Sorry, madam. Lord, may take into note of first on a notification dated 6/6/2030.
Page?
Page, my lord. 83, my lord. Page 83. Prior to that time.
83 years.
When the report of the second proposed notice was rejected, a new inquiry officer was, my lord, appointed. The authority was silent till March 2013. On 6 June 2013, another notification has been issued showing a different ground. May I read it out? Whereas the departmental proceeding has been drawn up against this to and so, by its so-called notice issued by this department letter 86/2005, Annexure D, that was done. Whereas the disciplinary authority is not satisfied with the written statement in defense that is so and so submitted by so and so. In
This is
reply
the
to the
appointment of the inquiry officer.
so far that part is concerned, first part relates to that this inquiry has been reopened because of that my reply was not satisfactory. But so far the rejection part is concerned, that is not mentioned.
No, inquiry is done only when your reply is not satisfactory.
Yes, that is the first part of the inquiry was conducted by that was not satisfactory.
No,
And-
but this does not reflect this. 83, page 83
Yes.
does not reflect that it had gone up to the stage of inquiry being over. Then not, they were not satisfied. They had initiated initially a de novo inquiry. Now, 2013, they said that no, as if a fresh inquiry was, for the first time an inquiry officer was appointed.
Earlier it was appointed, inquiry officer engagement appointed. Since he has retired, so fresh inquiry officer has come for concluding the inquiry.
Where is the retirement aspect here?
That is that second para of the third para of that particular notification.
Yes.
Page 83. Therefore, the undersigned so and so in exercise of powers conferred under so and so appoints Sri R.N. Sharma, additional director, handloom and textile, as inquiry officer to inquire into the allegation and all the charges in the aforesaid departmental proceeding against the Pulinda, the assistant so and so. Again, I Sri Durgadhar Bonia, so and so, since retired. The inquiry officer will enter into the allegation and all the charges and submit his report and find.
Okay, then
Then, my lord, so far, that note, I have filed my lord reply on 7/9/2005, and that was my lord concluded, and its conclusion is at my lord page 132.
132.
132. It is the inquiry report against the my lord second proposal.
Yes.
May I read it out? The inquiry was conducted in pursuance of the order number 22 dated 8/8/2013. The inquiry was conducted to inquire into the allegation and all the charges against so and so, the then assistant director of so and so. As is evident from the order mentioned above, the inquiry was necessitated because of non-satisfactory written statements submitted by so and so, the then assistant director of so and so. The previous inquiry officers, as the referred to, conducted a detailed inquiry, and after completion of the same, a report was submitted to the commission so and so by letter that is present. In their report, they categorically pointed out that the charge level against so and so, the then assistant director of so and so, had been proved. They also furnished all the relevant papers, documents with the report. The fact is that, as is evident from the order number 22 dated 8/8/13, the disciplinary authority was not satisfied with the written statement in defense dated 7/9/2005 submitted by Steve so and so. This time too, the written statement of Steve Pulindas, the then assistant director of so and so, does not differ from much from the one he submitted to the previous inquiry officer. The same is appended as Annexure 1. Even the replies furnished by so and so, the then assistant director, are also similar to the ones submitted to the previous inquiry officer. The same has been appended as Annexure 2. As such, I, as the inquiry officer, am of the opinion that my conclusion on the allegations and the charges against so and so, the then assistant director of handling and textile, is same with the one of the previous inquiry officer, the B. Dev, joint director of handling and textile account, as the Purindas could not produce such documents which could prove his non-involvement in financial irregularities, insubordination, and negligence to duty. The statements are mere denial of his involvement in the financial irregularities, insubordination, and negligence to duties without any satisfactory and corroborating evidence. And the inquiry report, which was rejected earlier, that has been accepted here. And so far, the rejection part is concerned, that is not mentioned, only that my reply was not satisfactory. That is why the present has been continued. And so for the earlier inquiry report is concerned, that was rejected only on the ground that no procedure was followed. So the findings which was arrived at by the authority without following the due procedural law has subsequently been accepted and followed in the subsequent.
No, the authorities of the reason for rejecting the first inquiry report was not adherence to the procedure adopted. But here, the findings, he is not disagreeing. He is agreeing with the findings, this present inquiry officer, but he says that I have adhered to the procedure laid down.
But page 133, the first part reflects that he has accepted the report finding
Yes.
of the earlier one. He wants to go with that earlier finding. Whereas that findings was
read page 60.
my lord.
60.
Second paragraph, my lord.
Yes.
On perusal of the inquiry report, along with the enclosure, it is seen that the inquiry officer did not follow the prescribed procedure in conducting the inquiry. The inquiry was conducted in a perfunctory manner without even recording the statement of the delinquent officer or examining any of the witnesses, leaving on the inquiry incomplete. Therefore, in view of the above fact, the Governor of Assam is pleased not to accept the findings of the report and further pleased to order a de novo inquiry into the charges brought against
the findings were not accepted because the prescribed procedures were not followed.
Even my statement was also not recorded.
Statement was not recorded.
But that report has been accepted in page 133 in the. May I read once again, my lord? From second line, as such, I, as the inquiry officer, am of the opinion that my conclusion on the allegations and the charges against so and so, the then assistant director, handloom and textile company.
Okay. Let us proceed now. He accepts the same inquiry report.
Same inquiry, whereas it was rejected earlier.
Same opinion.
Page 134 is the conclusion of that inquiry. Thus, I found no way but to be the same opinion as that of the previous inquiry officer P. As far as the allegation and charges against the Purindas, the then assistant director said.
Yes.
In this proceeding also, my statement was not recorded and I was also not given opportunity to adduce evidence. Even no statement was recorded.
But what about the enclosures? Enclosure number 4.
Enclosure as regards to my written statement. So for report of the previous inquiry officer report is annexure 3. My was annexure 2.
Did he hold any inquiry, this person?
No.
Was any inquiry actually held?
No. Actually, my lord, after submission of my reply, I have not given any notice to take participate in that. Okay. Even my lord, the report itself, my lord, is silent. about recording any statement of any other witness.
Mr. Dhar,
My lord,
this 132 to 134 does not even reflect that there was a proceeding. He simply examines the previous report. He endorses the report. There is no independent proceeding. Now see, earlier at page 60, the rejection of the inquiry report was on a very technical ground, that the procedures prescribed were not followed. And therefore, de novo doesn't do, he simply endorses the views expressed in the earlier report. There is no inquiry at all. At least reading does not even remotely reflect that there has been any separate proceeding.
my lord, we have, in our acquittal, we have brought in a inquiry report, my lord, dated 4/9/2009 by Chief Bora. In our affidavit, it was the second.
And kindly see at page 133, Mr. Dhar. Mr. Dhar, the strict rules of Evidence Act may not be applicable, but see how he has shifted the burden of proof. First paragraph. He could not produce any documents which would prove his non-involvement. He has simply denied. Thereafter, what happened, Mr.
My
Sharma?
lord, first proposed notice has been issued.
Another separate charge.
Separate, sir. My lord, charge reflected in the first proposed notice and the second proposed,
Mixed together.
along with my lord, new charge.
Page
My lord, third proposed at page 63,
63.
only 63. Annexure 8, page 63. 8 charges are here. My first source relates to my lord. I was unauthorized there. It was the only also the allegation that I failed to attend DDC meeting for last 3 months prior to 14th 2030, and I have suppressed my address and telephone number. Charge number 3
Yes.
is also my lord relates to my lord my unauthorized. Apart from read my lord, while you were working as assistant director, you informed the director of pension that you required leave from 5th February to 9th February for medical examination at New Delhi. By your letter dated 3/2/2007. Later, you gave another petition that is went through, stating that the leave be converted into earned leave from 5th to 28th February 2007. However, you had neither submitted any application for earned leave in proper format nor handed over charge to anybody of your office. Instead, you visited your office and also the government by giving an order to Sri Abdul Halim, DSP of your office, to look after the day-to-day work of the office for the period from 5 to 2007 to 11 to 2007, stating that you were on casual leave. Further, you sent the application of 3rd February 2007 as stated above to an unknown person, ostensibly to keep the office in dark about your leave and to avoid handing over charge. In fact, you took leave and thus stayed away from office without taking leave. This leave was reportedly extended for the month of March 2007 on the pretext of death of your father. But this time also you did neither apply for leave nor inform the director of Handloom and Textile, and also you did let your office to know that you were on leave. As per office record, you have not applied for the earned leave for these 2 months till today, 18/6/2007. Hereby, you had willfully cheated the government for enjoying paid holidays without deducting any leave from your leave account. On the other hand, without applying for earned leave and without the same being sanctioned by government, you drew your pay for the month of February 7 and March 2007. In this regard, it is observed that no leave was actually applied, no charge of your office was handed over to anybody, and in the office, thus putting the office work in jeopardy. Misled the office by stating that you had been on casual leave from 5 to 7 to 11 to 7 and willfully keeping the office in dark about your leave. Number 4, did not inform even the director, Element Textile, that you had applied for leave for the month of March 7 and cheated the government by obtaining your pay for month of February and March 2007 without applying for leave and staying away from the office on the pretext of being on leave. Therefore, you are charged with negligence of duties, falsification of records, willful violation of office rules and procedures, and also misappropriation of government money to unauthorized withdrawal of your salary and cheating the government, and also lack of integrity. Charge number 4. While you were working at ADHD Kualpara, the UD of the office, Sri Narayan Sharma, retired on 31/12/6. At your initiative, Sri Narayan Sharma handed over charge to you, and you did not allow anybody of the office staff to take over charge from Sri Narayan Sharma and kept the cash book and all other registers of the cashier by yourself. On examination of the cash book, it was found that the same had not been retained since 1st January 2007 till the date of unilateral taking over charge by Sri Vipul Kolita, the present ADHD in charge, on 9/4/2007. There is no record of transaction of government money during the period 1st January 2007 till 9th April 2007. The Director of the Handloom and Textile released the following amounts to the ADHD Kualpara. That part has been mentioned. Thus, you did all the work in giving sanction of drawal, executed drawal, and disbursement, and kept all the amounts also. This clearly spelled a sinister attempt to misappropriate public money, since you did not allow any person of your office in the entire process of public expenditure. Besides the above, you drew salary stipend etc. during your incumbency as the ADSP Kualpara in detail. It appears that you had drawn an amount of rupees so and so. However, due to non-writing of cash book and other books of accounts, the accounts of the above government money for drawal and disbursement is not available. It transfers from the action of your debt. You had committed the following irregularities: kept the cash book and other register in your custody in violation of existing government rules, did not write a cash book, and did not maintain other accounts of expenditure of the office since 1/17 till 9/4/2007, resulting in non-availability of records and drawal of disbursement in your office, which is a serious lapse on your part. Third, you did such irregularities willfully with an ulterior motive of misappropriating government money. Fourth, the entire amount as shown above may be construed to have been misappropriated in absence of any report of the disbursed amount. Therefore, you are charged with indulging in willful and calculated violation of financial prostitute with a sinister motive of misappropriating government money, willful negligence to duties and reckless conducting official work, committing willful irregularities with an ulterior motive to steal the government by creating a mess of accounts and absolute lack of integrity with misappropriation of government. Charge number 5. While you were working at ADHC Kamrup Guwahati, you should supply orders to a large number of firms for supply of looms and accessories with several crores of rupees. Some of such firms persons to whom supply orders were given by you, along with the value of materials are given to. The amounts have been mentioned specifically herein. Therefore, there are numbers of other firms to whom you had willfully issued supply orders. In this regard, it is observed that the government of Assam had not sanctioned any scheme under which so many looms could be purchased, and that there were no sanctions whatsoever for purchase of looms and accessories by the ADHC Council. You as ADHC had no authority to purchase looms and accessories without prior express approval of the government, the Directorate of Handloom and Textile. You had as ADHC neither any authority to call tender for supply of looms, nor did you call tenders while purchasing the loom. The Director of Handloom and Textile is the authorized person to call tenders. You had arbitrarily selected suppliers and arbitrarily fixed rates of supply of looms and accessories without authority. Governor and the Directorate of Handloom and Textile Assam did not sanction any scheme for purchase of this loom. 5. Supply orders were given secretly by you along and anybody in your office or in the office of the Director of Handloom and Textile or at the government level was aware of any such orders. File number was quoted fraudulently as the office of the ADHC Kamrup does not have any file having the numbers given in the supply order, and such file could not be placed in the office so far. In the case of supply order to Messrs. Global High-Tech Enterprises, you had issued 2 checks of rupees so and so and payable at Punjab National Bank so and so. In case Messrs. Purbanchal Traders, you had also issued a check of rupees 4 lakh something payable at the same time. All these checks bounced because of having no money in the account. You had opened bank accounts secretly in the nationalized bank in total violation of government instruction, prohibiting opening bank account by government officer without express permission of government. The checks were issued by you with full knowledge that there was no money in the bank account. This you clearly did not did to see the suppliers and the government. In fact, the government had never given you any money for the purpose. 9. All these violations were done transgressing in official authorities and misusing official status. As an officer of the state government having years of experience, you were not.
Okay, you may not read into the details. We have just had a cursory glance.
Mine.
8 number charge.
Mine,
Thereafter, what happened?
Charge number 5 relates to criminal conspiracy, falsification of records.
Yes, we have read this. 5, 6, 7, 8. We have read this.
Mine.
What happened thereafter?
My lord, so far, my lord, charge number 5 is concerned. The charge number 3 and 4 of the second show cause notice are similar to it. Charge number 5. The allegation.
Yes. Yes.
Second show cause notice is at 45. Charge number 5.
Yes. You are referring to 18/6/2005 notice.
Mile.
Yes, we have noted.
So far, my lord, charge number 8 is, my lord, also similar to that of the first show cause notice.
Yes.
Both charge number 1 and 2 have been tucked together. Charge number 8.
Yes.
So far, my lord.
What happened thereafter?
Thereafter, my lord, my lord, inquiry has concluded and submitted the my lord inquiry report.
Report submitted.
Right.
Page.
Page, my lord. 97, my lord.
Yes.
All the charges have been, my lord, shown as proved. Moreover, my lord,
Hmm.
all the charges have been proved. The opinion was such that considering all the above points, I come to the conclusion that continuance of an officer like the third officer in service will harm the government to a great extent. According to my lord, the impugn order has been passed. Page 117.
1, 1.
7.
And you are given a second show cause notice on this inquiry report.
As well, second suppose and third suppose.
No. Don't use the expression second, third. We'll say show cause number 2, show cause number, because second show cause notice will mean something else.
Right.
After the third
After
number,
the third, my lord.
you are given a second show cause notice after the inquiry report.
Yes, yes.
You
I am
replied to
given a
it.
reply.
Yes. Where is your reply?
Reply is it, my lord, page 111, my lord.
Yes. 22nd October.
Yes, my lord. Reply against the inquiry.
Yes.
Now the
Where is the report? Where is the order?
page, my lord, 117. 30/10/2015.
117, yes. 30th October.
30th October. Page 117, and effect.
Yes.
I have been, my lord, removed from service.
Okay.
In this order, my lord, it is reflected that both the inquiry report have been, my lord, taken together, my lord, and accordingly this order has been passed. In accepting the inquiry report,
Yes. Yes, what are your grounds?
now, my against, my lord, this I have preferred an appeal,
Departmental appeal.
departmental appeal, my lord. When the matter was pending for a long time, I approached this honorable court for disposal of that appeal, and accordingly, my lord, the appeal was also, my lord, disposed of, but against me, my lord. Annexure unit, page, my lord, 130.
Page 1,
144, my lord,
144.
144.
The earlier writ petition was 793.
My lord.
Disposed of 10-2.
My lord.
One 44. Nine 29 March.
My lord, 29 March 2018. Next is the type copy, my lord.
Appeal rejected.
Rejected. My appeal has been rejected.
Yes, grounds.
Accepting the, my lord,
No, your grounds now.
now. And so far the second report, inquiry report based on the second report, I have already submitted. And so far the final report, inquiry report, which was derived from the third so-called disciplinary. While inquiry was conducted, I was never been excluded.
Never?
Never been in. Because of the ground, that has also been reflected. That has also been reflected because one of the charges was such that I concealed my address as well as my phone number. That was one of the charges. And so far, my residence and as well as my physical status. In 2006, my lord, I was attacked by the heart disease. My lord. Accordingly, I went to Delhi.
Medical.
Medical. On medical ground, I was on leave. I have filed application on leave. That was also reflected in their notice also, so-called notice also, that I filed application.
Yes.
And my leave was also extended. That was also reflected here.
Hmm.
And so far, the inquiry report is concerned, nowhere, my lord, other charges have been shown as true, except, my lord, the statement of the person who has deposed before the inquiry officer as regards to my absence. My absence was they have there is nothing more than that. And so far that
You are not given any opportunity in this
as per
inquiry.
the authorities concerned, they have stated that they have sent notices to me, but those notices were sent to the Golbara office, whereas I was suspended therefrom, and I was on medical ground, treatment, and while I was during the suspension period, notice was sent to the Golbara, where I was lastly posted, and no notice regarding my participation, no reply against the their contention has been given opportunity to me to defend my case properly.
Properly means
I was so far the day-to-day hearing or whatever.
you are not. Weren't you aware of the inquiry?
Madam,
Weren't you aware of the inquiry?
so far the inquiry part is concerned, that notice has been received to my brother. I have received the notice to my brother. After thereafter, I have submitted my reply. Thereafter, I was on medical leave, treatment. Subsequently, so far the disease and date fixed by the inquiry officer as regards to the disciplinary proceeding is concerned, I was never given intimation.
That is your main ground.
Basically, that part was there. The second part is the charges, what is level against it to the third so-called notice is concerned. The authorities has clubbed together the charges which are already, my lord, second disciplinary proceeding was conducted and concluded, and the first one, so for that part is the petitioner is not aware of what happened to that first so-called. So the charges in the reflected in the first so-called has also been brought to this third so-called. That cannot be done because already they have taken consideration of, taken note of that irregularity and such. So for the second inquiry report is concerned, at first, when the report was submitted, that was rejected, and subsequently that has been also accepted, and that is also taken into consideration while the appeal has been dealt with by the authorities as well as the punishment order. That part also been taken into consideration. If you also take note of that, the input order as regards to my removal is concerned 117,
Yes.
page 117, last two paragraphs. Whereas on perusal of inquiry report in respect of the charges drawn up by so-called notice number dated 18/6/2005, it is found that the charges are proved against the Pulindas, the delinquent officer. In respect of the charges, drawn up by so-called notice number 12, that is 12. It is seen that the charges of misappropriation of government money to the tune of rupees 30,956 is fully proved. Whereas after careful of examination of two inquiry reports of the inquiry officer and conjunction with the materials and records, not only the findings of the inquiry authorities are found to be acceptable, but the same in time Suprind is also found to be habitual offender in monetary matter, as well as the negligence of official duties. And whereas on the above findings, it has been decided to accept the findings of the inquiry officer and the penalty of removal from service is awarded to the Sri Punindas. Whereas FPC has conveyed its approval to the proposal of imposing the penalty of removal of delinquent officer from government service under provision of so. Now, therefore, the governor of Assam is pleased to accept the inquiry report and remove Sri Pulindas, Assistant Director of Handloom and Textile, from the service of the government of Assam in the Handloom and Textile Department with immediate effect. So, my lord, both the inquiry reports have been accepted. That cannot be so for the second first inquiry report, which is based on the second so-called concern. That cannot be accepted as for punishing me for punishment, because the charges and the procedure adopted by the authority, it was not in accordance with that, because I was not given any opportunity to take part in the same. Again, my lord,
You have the record, Mr. Dhar?
Record, my lord, but the entire record is not there. But without that, even my lord, I can go ahead then.
How do you club separate show cause notices? And that too after completion of an inquiry.
My lord, it's like this.
And finally, removal order takes into account an inquiry which was done. Which was the, what was the date of the inquiry report?
inquiry report, my lord, 49.
4/9/2009. Right?
Ji, bro. 4/9/2009 is the last inquiry report.
No, 49 is the acceptance of the charge.
Charge, my lord.
Then the removal order
Removal.
takes into account not only 49/2009. Removal order is of which year? 2014.
No, 15, my lord.
The removal of 2014, 30/10/2014, I think. Or 15.
15.
30 October
30/10/2015.
15. Oh, okay.
Page 117.
Yes. Right, you're right. 30/10/2015, 6 years after the inquiry report, that may be so. But this removal order takes into account not only 4/9/2009, but even an inquiry report which you don't even know when it was conducted, when it was at 132. One page
132.
132.
12/8/2014.
Do you have the date?
12/8/2014.
Where do you get the date? 132. Where do you get the date?
My lord.
From where do you get the date?
That is not mentioned in my lord, in the inquiry report, but I have got it from.
From where do you get it?
It is dated. Do not remember. Beautifully, एक मिनट.
It will definitely.
I have got it somewhere, my lord. I note it down.
And in any case, 132 is not after any procedure. 130 is simply reiteration of the earlier report. Earlier report not accepted. All hodgepodge.
it's like this, my lord. When the department went into the thing, my lord, he was like a coconut. The department kept on, my lord, opening up one after another, and his different allegations, my lord, at different level it came up, and they kept on clubbing, my lord. That is become an ultimately that 2009.
No, you can, there is no bar in law that you cannot have two proceedings.
Yes, ma'am.
Some new charge may be there, but in the name of new proceeding, you have brought back other old charges. At least in charge number 5, you have incorporated the charges numbers 3 and 4 of the second show cause number 2. And in charge number 8, you have taken into account charges numbers 1 and 2 of the show cause number 1. How can you do that? This will be unending. And even if we ignore charge number 5 and charge number 8 on these grounds,
My lord.
the removal order takes into account the earlier inquiry report.
But my lord, he did not join, my lord. That is clear, my lord. From this report, my lord, acceptance report of 4/9/2009, that he was given 3 notices, my lord. The address was given by him to the commissioner, and he, my lord, did not participate. He, my lord, shied away. He avoided. That is there.
Mr. Dhar, let us accept that, except for charge number 5 and 8, which we cannot accept, I emphasize. For the other charges, let us, for the time being, hold that the inquiry has been done. He did not, on his own volition, he did not participate. He avoided. There's a report. And the report has, while accepting the report, the disciplinary authority goes back to which date? To an inquiry report of 2007. Why was the need? And where is the, not only the need. Let us read again the impugned order 117. 117. In 2005, this proceeding was not before him at all. In 2007, yes, okay. 1907, 2007 is there.
Yes.
Why is it referred to 2005, 18/6/2005?
Whereas the disciplinary proceeding 1 by focus is dated
18/6/2005.
The typo mistake or
No. Then you keep on reading. It's not typographical. Whereas 2 departmental proceedings. First, one by show cause of 18/6, and the second one, you come to the 5th line, 1907.
2007.
He should have confined to 1907. Matter ends there.
Yes, that is not subject matter matter there in it.
And if you come to the reply to the second show cause, reply was sought for, again, so far as the inquiry report of 1907-2007 show cause is concerned. Inquiry report is 4/9/2009. Come to page 111. 111.
Yes.
Subject, submission of representative against the inquiry report 4/9/2009. There's nothing to do with the earlier report. Earlier report is gone. Do you have a copy of the second show cause notice, Mr. Sharma,
My lord,
to which you had replied on 111?
111 is against my lord, third, my lord, report, last report, and last inquiry, 4/9.
No. Do you have the show cause notice
My lord,
by which this report was forwarded to you?
that notice is not.
This will be 9/10/2014. Where is 9/10/2014?
6 June 2013.
No.
96.
910. Its reference is 910 2014. Come to page 111. We want to know what was forwarded to you. Was it the last inquiry report or even the previous inquiry report? Mr. Dhar, have you seen at 111?
My lord, yes.
Reference
Reference is for 14, 910, 14.
910. You have 910 to 14 letter? Don't have.
Ninety-six, my lord.
96.
96, my lord. The letter. I am directed to enclose here a copy of the inquiry
Yes,
report.
yes. That we need. 96.
96.
Is it 910? Yes, 910.
My-
The inquiry report. See,
Oh,
it's the only that is the only inquiry report. Now, how can the disciplinary proceeding authority take into account the earlier inquiry report? There's nothing to do with this proceeding.
They clapped it.
How can? Show cause notice was given to him only on this report of 4/9/2009.
After 5 years.
Charges are so serious and you act in such a perfunctory manner. Serious. At least minimum semblance you have to, you should have maintained. Now, what is your status, Mr. Sharma? You retired.
No, my lord.
One
Just
day-
one day ahead of my retirement, I was just one day ahead. On 31st of August, I was to retire from my service, but on 30th of August, I was married. Unfortunately, after long gap, my lord.
He enjoyed his time in the department.
But 19 he came to the court. There was no delay in coming to the court. Appeal was rejected in 18, 29/3. He came in 19.
Yes,
Within time, I have appealed.
This kind of proceeding procedure we cannot endorse. Difficult. And you have made it so clumsy now it cannot be remanded also. What stage? Which inquiry report?
my lord, it has to go back to the notice. Where we have sent him notice, he did not participate.
We have accepted your argument. He did not participate. Inquiry report is against him. But was it the only consideration before the disciplinary authority? Question is this. That was not the only consideration. He took into consideration an inquiry report of 2005, which was not even the subject matter. We are not even accepting Mr. Sharma's version that he was not well, he had gone for treatment, and his brother has accepted. Let us assume that he has on his own, he has avoided the inquiry. Inquiry may be held ex parte, good. Act on that. You asked for his response, he gave his response, act on that. While acting, you go back to 2005.
Suppose, my lord, if you don't take even consideration of 2005, But still, my lord,
You should have,
there are other judges.
you
my
should
lord.
have,
There are
but
civil
that has,
judges.
that has vitiated everything. How can you remove it now? You cannot dissect. That is what played in the mind of the inquiry, disciplinary authority. Now we cannot say that, no, this can be ignored again, this can be sustained. No, cannot be. There is no requirement at all to have even a mention of that. He started with that, two proceedings. He was not there to decide two proceedings. And 132 inquiry report otherwise also cannot be acted upon. There was no proceeding. And he has simply endorsed a previous report which was earlier rejected by the government. Page 60, 19/8/2006. Inquiry report not accepted. De novo inquiry. That procedure, whether that procedure is a correct procedure, that is even a debatable issue. Not even debatable, it's not the correct procedure. You cannot do de novo. You may have reasons to disagree, give him a notice, matter ends there. Removal will not cannot sustain removal. Unfortunate with these kind of allegations.
We
Have to give him the pensionary benefits. If you have the records, we'll close this. Heard. Shri M.K. Sharma, Learned Counsel for the petitioner. Also heard Shri Ardhara, Learned State Counsel, who has also produced the records of the disciplinary proceeding. Hearing is concluded, judgment is reserved.
My lord, pensionary benefits may have settled.
Yes. People. Oh,
Obliged.
Mr. Bora, what is it?
That order was almost similar, but that notification which was reflected in the first order, that part is not recorded in the judgment. Past
Kindly
order.
fix the matter for hearing, Lordship.
Then we'll have it some other day.
I am under the Lord.
But if ignoring that part, we can still dispose of you. If you agree, we dispose.
No, my lord, yes,
Otherwise,
it has already reflected in the first order itself.
No, if it is not there, we can ignore it.
Lordship, I have that. This judgment is better. Second,
We'll have this day after tomorrow. You try to clarify this part. Day after
Sure.
tomorrow. Okay.
Fine.
Dispose of matter. Item number
40.
on a joint request list on Thursday. That is, I think, a small issue. That part we can
Small issue.
avoid that part.
As per notification, that approval is not necessary. That much
Okay.
on Thursday, ma'am. Obliged.
Item 10, continue.
My lord, the other day, the government filed an affidavit and was projecting an absolutely wrong picture. Now we have filed the reply, my lord, where we have brought in everything.
an impression was sought to be given that I am not an faculty member of the institute, my lord. The lordship should kindly have the reply.
Reply filed in the writ petition,
Yes,
3769.
yes. I have next so many documents. I'll just refer to just for an
Where is the state council?
Here, but I have one different petition.
Mr. Dhar, Mr. Dhar, a reply has been filed?
My lord, nearest pilot reply. my
No,
lord.
no, where is the copy? This copy is not here.
My lord, it fixed the matter on Thursday.
no, Thursday. It is on Monday. Thursday I'll be out. My lord, they gave a wrong picture, my lord. I have brought out everything.
No, no, it's
I'm
okay.
not only a faculty, I'm just so one document.
No,
my
we
lord.
will consider that
Yes.
is not before us. That
Yes.
reply will have that.
Oh, sorry. Then-
We can have that implement of Mr.
No, my lord, implement also I am objecting, my lord.
You file objection.
No, we are filing, man. We are objecting because he can't become director under any circumstance. He doesn't have the eligibility. So end of the day, my lord, he must have the eligibility.
What is the implement about? Mr. Fukan,
My lord,
what is the implement about?
yes, my lord, I am working as associate officer
Okay.
and eligible for the post of director. And so I'm experienced for that post. That is one point. Second point is this, that he is holding the post very illegal. So I have some information and documents, and I want to submit it to assist the honorable court for passing a.
We'll implement him.
My lord, I have otherwise no objection, my lord.
Hear him, no problem.
No, I don't. Otherwise, the lordship is inclined. I have got nothing to say. But my lord, he is not at all either a necessary party or a proper party in this case.
No,
That's my submission.
That will decide, but whether we accept his,
Okay.
that is a different matter.
Okay.
In the hearing, he'll participate. That's
All
all.
right.
Monday, we are having the hearing.
Monday.
Okay. Heard Sri K.K. Fukan Learned Counsel for the applicant, who by means of this application has prayed for his implement as respondent number.
My lord.
Respondent number
8.
In the connected WPC so-and-so. It is submitted that the applicant is an aspirant for the post of director
Yes.
of the LGBRIMH Tejpur, and the writ petitioner opposite party is not legally holding the said post. Full stop para. The aforesaid submission, however, has been strenuously opposed by Sri K.N. Chaudhary, learned senior counsel for the opposite party writ petitioner, who further contends that the applicant is neither a necessary party nor a proper party. Full stop para. After hearing the learned counsel for the parties, this court is of the view that interest of justice would be served if the applicant is given an opportunity in the hearing of the connected WPC, connected writ petition, full stop. The I accordingly stands allowed, and the incumbent and the applicant is to be arrayed as respondent number 8. In the main here, right? WPC. By an order passed today, that is so and so. IF number 2434 of 2024 for implement has been allowed by implementing the applicant in that case as respondent number 8. Para. Miss, you're there on record, Miss Kotoki?
Yes.
Shall file an amended cost title incorporating the name of the newly implemented respondent number 8 within a period of 3 days from today.
The interim order will have to.
Yes, on request list for consideration
On Monday night.
On Monday. Great, huh?
My lord,
Tonight.
office may be, the reply may be
Oh, yes, sir.
raised on. It
29.
was filed on 22nd.
उससे पहले लिखो.
Oh,
It also transpires that the reply affidavit filed by the petitioner is not tagged with the records. Office is directed to have it tagged. Para? On request? No, on request list on 2nd of September 2024. Para? Interim order passed earlier to continue till the next date of listing. Mr. Fukan, would you like to file some affidavit or what?
Yes.
But file it within a day or two. They should get a chance.
11 also may come up on Monday, Peter.
Monday. What is the matter?
Suspension.
Some order has been passed.
No, my lord, question is, order is passed in June.
No, new order, some new order. I do not know. We have not seen we do not know the subject matter. Some
But this one,
August order.
Oh, my lord, but it has to be passed within that 3 months, my lord.
What
And
was
let
your
it come up on Monday.
okay? What was your case?
My case was, my lord. in
Initial
terms of-
review was not within 90
No,
days.
no.
Oh, this will not cure. Madam, this will not cure.
Lordship, within 90 days, Lordship, Shokos was issued.
So what? Even then.
Yes, Lordship.
But 49%.
Yes.
If you take a look, regarding para 20 proposal. 50,000 clear.
Okay, on
Anyway, I'll clarify on Monday.
Monday. Okay.
Extra copy is also not start off.
কি?
Problem is the
Copy দিয়া নাই? কিনো কৰা?
Here for the revenue department. Okay.
And I will give.
On request.
GAD.
On request. List on
Monday. my lord.
Monday. Same date, huh? Second.
Give.
problem.
Oblige, your lord.
Sir, my lord, they have brought the record for topic.
What is this, Mr. Chaudhary?
Otherwise, your lordship, I don't have any objection if the similar order which is placed at page number 40, similar order is compulsory.
What was it? What is it?
Page number 40 of the rejoinder.
No, what is it about? The matter?
My lord,
Basically,
matter
this
is, my lord, I was imposed a penalty of removal from sir.
Oh, parity.
Yes, ma'am.
Parity.
Altogether.
Some
each
other
person
matters
should-
have been dealt with.
Yes,
Yes.
Page
page, the effective portion is page number 40
of the rejoinder.
of the rejoinder. Wherein his other co-accused, he was also removed and he was, his punishment was modified to compulsory retirement
By the appellator.
by the, not appellate authority, by the council court.
That is only one.
One,
That is only one.
one of them.
40, we cannot give order of this kind. This is a 26 page, 27 page order.
Yes, sir.
After full consideration. We can
Yes.
say it is covered by that.
Covered by,
Same facts.
same,
Relating to the same incident.
same.
If lordship may kindly come to page 141, the punishment was given. Page,
We cannot act so mechanically, Mr. Chaudhary. You have to give us small
Yes.
written kind of a thing. We'll dispose this of. When can you give? Day after tomorrow?
yes, sir.
We'll follow this, but we cannot just say that covered. We have to apply our mind.
Yes, because
Okay.
he is
Uh,
young person other.
There is a general consensus in the bar that the matter would be covered by an earlier judgment of this court pertaining to the same incident. Full stop, para. Let the aforesaid aspect be to be considered on the next date, which is fixed on day after tomorrow.
Give less.
Yes.
Can we have it on 10th, my lord? Already one other side has left, my lord, agreeing a date, my lord. The 10th of September.
What is the matter about?
I mean, a termination, my lord. I am a
They should
constable
have
driver.
told the court, we would have left too. We cannot leave till 4:45. Termination of from service.
Yes, I was a driver constable, my lord.
Which department?
Sastra Sima Bol, my lord.
Okay, CGC.
Eke Dotto was here, my lord. He was just
Who? H. Gupta.
Eke Dotto, my lord. Ajit Dotto, my lord.
Okay, okay.
He was here, my lord.
Okay, okay. When?
10th of September, my lord. 10th of September, my lord. Tuesday, my lord.
Okay. On a joint request?
So, joint request,
On
my lord.
request, list for hearing on 10th of September.
Obliged.
Yes.
The departmental proceeding case, my lord. We have challenged the input order by which imposed the penalty of stoppage of one increment with cumulative effect.
With cumulative effect. What was the charge?
My lord, the charge is regarding, my lord, a criminal case lost against me. And pursuant to that criminal case, departmental proceeding as well as the criminal proceeding simultaneously was running. And subsequently, before completion of the departmental proceeding, he was honorably acquitted from the
Honorably?
Malad?
Honorably.
No,
Honorable.
He was honorably
Yes.
acquitted. Let us see that expression.
Yes. Malad, the judgment can see page 60,
60.
60, and the relevant portion, my lord. Page 74.
74.
Yes. When, my lord, the prosecution could not prove his presence in the place of occurrence.
In a conspiracy, is a presence required?
Yes, my lord. Here in this, the allegation.
No, I'm
is-
telling, if the charges of conspiracy, is your presence required?
Charge of conspiracy, my lord, presence is not required.
Then,
But here in this case, my lord, tell us the page 74, now having considered the discussion above, without going into the details of the ingredients of the alleged offense.
benefit of doubt. Okay,
Benefit
nonetheless, you are acquitted. Then
Yes.
what had happened?
My lord,
Then what had happened?
that has been communicated to the departmental authorities, but thereafter, subsequently, the punishment has been imposed on the petition.
Punishment of removal.
Yes.
One increment.
Now, one increase, stoppage of one increment. My basic ground here is that the charges in the criminal case as well as in the departmental proceeding is same set of allegations without any iota of difference. And the witnesses which has examined in the criminal case as well as in the departmental proceeding are the same. So
What are you relying upon? GM Tang?
Relying on GM Tang
And
and subsequently recently in 2024, that is the Ramlal. This judgment relying upon the GM Tang also and the M. Paul Anthony. That three judgments.
okay, we'll need some. Yes, Mr.
Day after tomorrow,
We have the records.
correct.
Let us have a look at the criminal charges and
Charges, Malad, kindly peruse
let us see the
page
so-called
24,
notice.
page
24.
24, the FIR, Malad.
24.
And 26 is the relevant person. Page 20.
Yes. Home guard in India.
And the statement of allegations, Malad, is at page 35.
35.
But ditto of the FIR. Malad.
What is that part where of the criminal case?
Malad,
Criminal acquittal case.
but criminal acquittal is at page 60 is the starting.
Not having considered it. It is clear, there is clear doubts in. Regarding the
74 is the relevant course.
without any other. Yes, but without emerge regarding the about the regulations. Where is the victim statement?
Millet,
Where is the victim statement?
victim statement,
PW 1, 62, page 62.
yes. But in cross Millet, she totally here Millet, the victim relied upon the PW2. He told her. But on that very day of incident, Millet, PW2 clearly stated he was there. Page 66. Totally a false story, Millet. Vital witnesses are two, PW1 and PW2. In page
This
60,
this judgment was not put to any further challenge.
Millet? No, not that. Even PW2 clearly stated that on the day of incident, she was in her quarter. Page 60. And victim story is that nobody was there. And even of the role of the
Okay,
SP.
When?
Yeah, but Millet on
Paucity of time. Paucity of time would not allow the matter to be taken up today. Full stop. Era. As requested, list on. Has the vote mixed matter fixed only?
120.
How much time on that? Have some other date.
Maybe a 5th, Millet. 5th of September.
Okay, 5th September.
Communication is already fixed.
5th September.
Matter.
Mr. Chaudhary, sorry, we could not give time today. did not reach. What is the matter about?
My lord, may I recollect on 12/9/2023, my lord, there is a order that to give one judgment that has been passed by your lordship in the similar matter, my lord. I have handed over to him that, my lord, here is a settlement. These people were engaged by, my lord, contractor, and here, my lord, they sought for regularization. My lord, in that case, lordship held that since there is a settlement and
18.
their union is
Section 18.
yes, section 18 of the industrial. The settlement is binding upon them, my lord. I have given them the judgment.
Mr. Perhaps you'd like to make some distinguishing.
Yes, no, your lordship is distinguishable because what has happened, your lordship, because with due respect, your lordship, that judgment should have been under section 19, not under 18. Because the fairness policy which they have relied has finished on 31/3/2017. And on the date of the judgment of your lordship, the settlement was not in fairness policy was not in existence here. Because because that was not pointed out to your lordship why it doesn't matter, your lordship, because fairness policy is clearly said that is terminating on 31/3/2017, your lordship. Then question of section 19 will come.
No, they, at that time,
It's
they
continuing under the
settlement.
on the basis of the settlement we are paying.
It's not
They are
that
getting paid.
there is no, because if your a fairness policy, because I am not covered, fairness policy, if your lordship will see, I will take your lordship the fairness policy.
Okay, we'll have a date fixed.
Your lordship, day after tomorrow, your lordship.
Day after tomorrow, 3 matters already fixed. There are other matters also.
Because
Previously
your lordship,
fixed.
because this matter, because your lordship, unless this matter, your lordship judgment is there, that's why.
No, not required that it has to be heard by this bench.
No, your lordship, have it day after tomorrow, your lordship.
Day after tomorrow, it's a matter of 2020. They are old matters.
Again, it will not be.
Your lordship, I'll take a chance.
22 meter,
Otherwise-
And the other Tejpur matter will take some time.
Yes.
So Tejpur matter tonight.
Let's put it on Monday, your lordship.
Monday.
Till Monday. So your lordship, have it day after tomorrow, at the top of the list, your lordship.
Top of the list, we can. 22 matters cannot be on top of the list. We can fix it on 20 day after tomorrow,
Yes,
but
your lordship.
you can take a chance.
Or cannot be on 11th, my lord.
No, 11, I cannot stay back so much. Because
Oh, you
last
come.
week also I stayed back and just 20th, it came to 25th.
Can it be on 3rd of September?
I won't be.
Okay, let us try on 29th. Otherwise,
sir, otherwise-
otherwise
Yes.
we'll go. Paucity of time would not permit the matter to be taken up today. Para, on request of Sri P. Chaudhary, Learned Counsel for the petitioner,
Yes, sir.
placed on 29th. Sri B.K. Das, Learned Counsel for the ONGC is present.
Reply.
What is the other? 321. Yes.
Look, departmental proceeding dismissal from service.
Charge.
Charge is taking gratification. But what
and
happened? They
grounds.
Well, initially they initiated the inquiry in 2016. Thereafter, inquiry report was given in 2018. Charges were proved. Thereafter, my lord, after 3-4 years, they issued an order for de novo inquiry. Then, actually, with the original first charge sheet, there was no list of witness, no list of documents. My lord. So they initiated de novo inquiry, and they have changed the inquiry officer also. And that inquiry officer gave a fresh show cause notice. Look, total violation of the
Inquiry officer gives notice.
Yes, my lord.
Show cause notice.
Show cause notice, my lord. She was appointed as an inquiry officer. She gave me show cause notice. Same set of charges of the previous one, my lord. Only difficulty is that, my lord, he has got only 1.5 year almost service left.
Okay, you have it.
And
we'll try to have it on either 5th or 10th. 5th or 10th.
5th, my lord.
5th we can
One
try.
small request I am having, my lord. This person has got another 2 matters, which are old matters regarding his promotion. So those matters are coming. If those 2 matters can be taken up along with these matters, my lord.
No, those matters are promotion. This is what? Punishment.
This is punishment
regarding punishment of
dismissal from service.
Then promotion, how is it?
So
if I succeed in this matter, then something will happen in those matters. Because in promotion also there was serious illegality.
Fifth.
Both the, I'll give the number.
No,
my
no,
lord.
no, I
Other
have
matter-
this first. We're
No.
not deciding promotion matters first.
my
We'll
lord,
have this first.
Because the promotion matters are 2012, the courts are finding it difficult.
Those will be infractious as of
No,
today.
no,
Let us first decide this.
fine, 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 my lord, fine,
After this, let us, even if you
fine.
are not
I'll
successful,
make a
then
mention, my lord. Yeah,
at least till the time you are dismissed, if you can get some benefit, it's benefit good.
yes.
A paucity of time, fifth. You're for the department? HK does, B Goswami edition reg.